Good afternoon, everyone, and welcome to this session of our criminal court. Ms. Bailiff, I'll ask you to call the case that's up today.
Your Honor, today's case, the State of Tennessee versus Peyton Patterson, case number 18-CR-1111.
All right. Is the prosecution ready to proceed?
Yes, Your Honor, but first preliminary matters.
All right, you may proceed.
Good evening, Your Honor.
Let me do one other thing. Is the defense ready to proceed? I want to be sure everybody's...
This also has some preliminary matters.
All right. Now you may proceed.
Good evening, Your Honor. My name is Eleanor Rankin, and I, along with my co-counsel, Adelaide Dashiff. Good evening, Your Honor. And Kiona Dordor. Good evening, Your Honor. Represent the people of the state of Tennessee in today's case. We will be calling 3 witnesses today. Tracy Benson, played by Autumn Nash.
Good evening, Your Honor.
Andy Anderson, played by Edith Caperno.
Good evening, Your Honor.
And Dr. Sam Wimberly, played by Meg Buter.
Good evening, Your Honor.
Thank you. Continue.
And now, Your Honor, pursuant to Mock Trial Rule 36, we ask to be allowed to move around the courtroom freely.
Yes, that shall be granted and shall apply to all attorneys.
And pursuant to Mock Trial Rule 33, the state asks to enter the agreed-upon stipulations into evidence.
All right. Counsel, I presume that has in fact been stipulated to previously?
Yes.
All right. Then those may be introduced and considered as part of the evidence.
Would you like a copy, Your Honor?
Yes, I would appreciate that. Thank you. If you'll hand it to the bailiff, please.
Yes, Your Honor.
Thank you.
And pursuant to Mock Trial Rule 17, we ask that all objections be made from counsel table for mock trial learning purposes.
Is there any objection to that?
As to objection arguments being held out behind the counsel table, it's a little bit of a confusing issue. I'm not sure that's addressed in Rule 17.
Why don't we just play that by ear and see how it goes? You understand who may make objections, and I don't know what will happen. So I'll reserve judgment on that for now.
Yes, Your Honor. And additionally, Rule 17 states that constructive bench conferences, which we all may call for during times in the trial, be held also at counsel table for these mock trial learning purposes and for the jury to be constructively outside the presence of these types of objections.
Counsel?
Again, Your Honor, an attorney might be in the well of court and not behind the table, so it would just be circumstantial as to whether that argument would be made behind the table or in the well.
All right. I'll reserve judgment on that as well. Thank you.
Yes, Your Honor. And finally, pursuant to Mock Trial Rule 13, we ask to have a timekeeper in the jury box.
All right. And that person's already seated. Is that right?
Yes.
Okay.
And with that, Your Honor, the state is ready to proceed.
Thank you. Does defense have any stipulations or other preliminary matters?
Yes, Your Honor. First, may I introduce myself and co-counsel? Good afternoon, Your Honor. My name is Samuel Watley. Joining me for the defense is Ms. Ella Seago.
Good evening, Your Honor.
Good
Mr.
evening.
Josiah Burns.
Good evening, Your
Good
Honor.
evening.
Joining us also at counsel table is the defendant, Ms. Peyton Patterson.
Good evening, Your Honor.
Good evening.
As the defense, we will be calling 2 other witnesses today, Ms. Frances Franklin
Good evening, Your Honor.
Good
and
evening.
Mr. Chandler King.
Good
Your
evening.
Honor, I'd like to direct the court's attention to Rule 16 of the Rules of Competition,
All right.
which says that witnesses may not be sequestered during trial, meaning they remain in the room. Also to elaborate on Rule 17, which opposing counsel brought up, stating that objection arguments will be held in the presence of the jury as they are the scoring judges. However, I would like to ask Your Honor's preference. Should we go ahead and assume that a constructive sidebar is being held, or ask at that time for a constructive sidebar?
Counsel, before I rule, do you have anything you want to say?
Your Honor, pursuant to Mock Trial Rule 17, we are supposed to ask for a constructive bench conference in which the jury is supposed to be constructively outside the presence of these objections. Therefore, we must call for the constructive bench conference first to assume that this sidebar is taking place.
All right. I believe that's what's being asked now, and of course at this point it's theoretical, but I'm going to go ahead and say, should a constructive bench conference be called for, that it may be conducted and that we will create for ourselves in our mock trial universe that the jury is constructively out of earshot.
Yes, Your Honor.
All right.
And lastly, I'd like to direct Your Honor's attention to stipulation 13.
Okay.
The indictment in today's case is second-degree murder. The stipulation simply states that no arguments of a lesser-included offense may be argued at today's trial. It's second or nothing.
Thank
With that,
you.
the defense is ready.
All right. Thank you both. Bailiff, I'm going to ask you, if you will, to go ahead and swear all witnesses. That will be a more efficient use of time as we go forward.
All the witnesses will stand. Do you solemnly swear or affirm that the testimony that you give today will be in accordance with the rules of the mock trial competition? I do.
All right, thank you. You all may be seated. Prosecution, you may call your first witness. And let me ask, can everybody hear me? Because I have not adjusted this. Okay, good. Call your first witness. Okay.
Opening statement for the state, Your Honor.
Yes, please, you may proceed.
How many coincidences does it take for something to no longer be considered a coincidence? On the night of June 18th, 2018, Rory Reynolds was shot in the head in the middle of a parking lot and died at the scene. But members of the jury, it was not a coincidence, nor was it an accident. And today, we will prove to you that Rory Reynolds was brutally murdered by her best friend, the defendant, Peyton Patterson. You see, the defendant and Rory, the victim, met in college. And after graduation, they each got jobs, and soon enough, they moved in together. Rory was a vibrant 23-year-old. She loved great music and had a guilty pleasure for fast food. But more importantly, she was an incredible friend to Peyton. However, what started out as a close friendship grew tumultuous. Their fighting slowly escalated over the course of a year until the night that Rory was murdered. You might be asking yourself, why? Why would the defendant kill her best friend? It's fairly simple. The defendant's ex-boyfriend, Guyan Rosling, broke her heart. And after their breakup, the defendant suspected that her best friend, Rory, had began a secret relationship with Guyan. And then on the night of June 18th, the defendant found secret love messages between Guy and Rory that confirmed what she'd suspected all along. Rory had betrayed her and was sneaking around with her ex-boyfriend. The defendant flew into a jealous rage. The fight was brutal. Neighbors heard it, furniture was knocked over, and the defendant's attack left the victim with bloody cuts, bruises, and lacerations all over her body. The defendant then picked up her gun, let jealousy pull the trigger, and just watched as a bullet came charging right through Rory's head. Members of the jury, that is why we're charging the defendant with one count of a second-degree murder. And with this, we assume the burden of proof. We must prove to you that the defendant is guilty of second-degree murder beyond a reasonable doubt. And we will prove to you that the moment the defendant shot the victim, she did so on purpose, knowing it would kill her. To help us prove this, we will be calling 3 witnesses to the stand. First, you will hear from Tracy Benson, the crime scene investigator who discovered the scene on that night. Detective will not only walk you through the gruesome crime scene that she found, but she will also tell you about how she uncovered the defendant's motive. Guy and Rory were dating. Then you will hear just how angry that made the defendant from Andy Anderson, her downstairs neighbor. Miss Anderson will recount to you all exactly how she heard the defendant screaming at Rory just minutes before she was shot to her death. Finally, you will hear from Dr. Sam Wimberly, the medical examiner who performed the autopsy of the victim. Dr. Wimberly will take the stand today and she will tell you that the victim died of a gunshot. She'll tell you how her body was battered and bruised, confirming that she was involved in a brutal fight right before she was shot. Members of the jury, as you listen today, I want you to ask yourselves, how many coincidences does it take for something to no longer be considered a coincidence? At the end of today's trial, it will become abundantly clear that coincidence after coincidence after coincidence is no longer a coincidence. It's knowing it's second-degree murder. So please, find her guilty. Thank you. Thank you, Your Honor.
Thank you. Counsel?
Yes, Your
Your
Honor.
opening statement.
May I proceed?
Yes.
From now until now. 3 seconds. That's what this case comes down to. Now today, these prosecutors are going to try to explain everything that happened in the 3 seconds, that what led up to the murder, what happened in the condominium, what happened in the car. But what they won't give you, what they can't give you, is what happened in the 3 seconds that really mattered. The 3 seconds right before the gun went off. They investigated carelessly, and they got it wrong. To start, think about what Ms. Dordor just told you. Peyton Patterson aimed a gun at her best friend's head, pulled the trigger, and killed her, all for the sake of jealousy over some guy she hadn't even been dating at the time? If when you heard this you thought, that's a stretch, it is because that is exactly what it was. More than that, it's downright absurd. Today, ladies and gentlemen of the jury, you are going to meet this young woman. This is Peyton Patterson. She's 23 years old, just graduated college. She has her whole life ahead of her. But instead of getting the start in life that she deserves, she is being railroaded into a murder trial. She's terrified. But today is her only day in court, and even though she has the constitutional right not to, she will take this stand. She will look you in the eyes and tell you that Rory Reynolds was her best friend. She would have never intended to hurt her, much less kill her. That is exactly what she tried to tell law enforcement on the night of June 18, 2018. But they weren't having any of it. Now, they wouldn't have just had to take her word for it, and today, neither do you. Because today, you're going to hear from an eyewitness who saw exactly what happened in the 3 seconds that really mattered. Today, Frances Franklin will take this stand and tell you that she watched as Peyton Patterson struggled to get something out of the back of her car, got stuck, lost balance, and that is when the gun went off. But for some reason, you'll learn that no law enforcement, no investigators, no one ever bothered to ask this one eyewitness a single question. Finally, you'll learn that if the government ever truly cared about finding out what happened during those 3 seconds, they would have had to look no further than their own employees. Today, you're going to hear from a forensic ballistics investigator who works for the state of Tennessee. And he will tell you that the gun that was fired that night had an especially dangerous characteristic, one that made it prone to accidental discharge. But once again, members of the jury, for some reason, no one ever bothered to ask him a single question from the state. And because they didn't, we did. Now, let me make one thing clear. It is not now and has never been our responsibility to do so. And that is because when someone accuses one of its own citizens of committing a crime, it must do so beyond a reasonable doubt. It is the highest burden we carry in our court system, and it will rest squarely on this table throughout the entirety of today's case. In other words, if at the end of today's case you're left wondering whether it was at least maybe an accident, not even probable or reasonably likely, but possibly an accident, then the government has failed to meet that burden of proof. Ladies and gentlemen of the jury, all they had to do was investigate the 3 seconds that really mattered. And because they didn't, we did. For that reason, we ask that you find in favor of the only verdict supported by both the evidence and the lack of evidence. And that is a verdict of not guilty. Thank you.
All right. Now you may call your first witness.
Yes, the state calls Tracy Benson to the stand.
And I'll remind you as you're being seated that you have previously been sworn in and are testifying under oath.
Yes, Your Honor.
Would you please introduce yourself for the jury?
Good afternoon. I'm Tracy Benson.
And could you tell the jury a little bit about yourself?
I've lived in Crater County my entire life. I attended Crater High School, and after I graduated, I then proceeded to go to Crater Police Academy. After being a patrol officer for 5 years, I realized that my childhood dream and current-day passion was in forensics. I've been a crime scene investigator for quite a long time now.
How exactly did you become a crime scene investigator?
Well, I've followed that passion in forensics to achieve a degree in forensic science from Crater State University in 2013.
How does your degree in forensic science play into your role as a crime scene investigator?
I'm able to take evidence that I find at the scene at hand and determine conclusions about a suspect or why the scene is the way it is.
How do you usually conduct these investigations?
Using my experience in crime scene investigation, I determine what to bag and tag as evidence and give to the state lab. But then I use my education in forensic science to determine the why and how the scene is.
Your Honor, at this time, the state moves to tender Tracy Benson as an expert in crime scene investigation and forensic investigation.
Is there any objection?
There's no objection, Your Honor.
Then she will be deemed an expert and may testify as an expert in those areas.
Investigator Benson, I want to move on and talk about the night of June 18th, 2018. What were you doing this night?
That night, I was called to a case at Cumberland Condos. I was on the far side of town celebrating a friend's engagement. I left immediately, and it took me about 20 minutes to get there.
What did you see when you arrived at the crime scene?
There were already tons of police officers, and the defendant was in the back of a police car. I was briefed by one of the officers and started my initial walkthrough.
What did you observe from this initial walkthrough?
The scene itself was covered in blood. When I went to the victim to examine her, I realized that her face was almost unrecognizable by the amount of blood both on her face and behind it.
Where exactly in the scene was this body placed?
Only 5 feet away from a passenger car door.
Would you say that's about the same distance as you and I right here?
Perhaps a little bit closer.
So about here.
Yes.
Now, Investigator Benson, did you notice anything else in the area of Rory Reynolds' body?
Yes, I noticed and collected a 9mm handgun and shell casing very close to the victim's body. I bagged and tagged those as evidence and gave it to the Crater State Lab.
After you investigated the crime scene itself, what did you do?
I went to the victim's condominium to look for more evidence.
What evidence did you find in the condominium?
After photographing the stairwell in every room inside their condominium, I went to the balcony. I noticed the door was unlocked as if it had been used that night, and a large wooden heavy chair was overturned on its side.
Did you find any other evidence in this condo?
Yes, in the kitchen, I found there to be 8 empty beer cans and a cell phone on the counter.
After you processed the scene in the apartment, what did you do?
I went to the medical examiner's office to examine the victim.
Did you find any evidence at the medical examiner's office?
Yes, I did. Rory had very few personal items at the time of her death. Besides her clothing, I immediately found a wallet, car keys, and a cell phone.
Now, Investigator Benson, I want to talk about the conclusions you made based upon the evidence you found as a crime scene investigator and forensic investigator. You testified earlier that there was a chair knocked over on the balcony. What is the significance of this in your realm of expertise?
Yes, I found that quite odd. In my expertise, I've found that overturned furniture suggests that there is an indication of a struggle.
Objection or speculation?
May I respond, Your Honor?
Yes.
This is not speculation because Investigator Benson has been qualified in the fields of crime scene investigation and forensic investigation. Forensic investigation includes determining the why of how a crime scene is the way it is. So when Investigator Benson sees an overturned heavy chair on a balcony, she then makes her conclusions based upon that evidence that there was a sign of a struggle.
Anything else?
Your Honor, if I may, as a crime scene investigator, her job is to collect, preserve, and analyze evidence, not come to conclusions as to what that evidence means. In today's case, that's the only thing she could testify to. That's the only thing she could testify to in her field of crime scene investigation.
I'm going to overrule the objection. I believe, having been qualified as an expert, that there are places where she may express opinions, but I remind the jury that those continue to be opinions and by cross-examination and other means may be tested.
Yes, Your Honor.
Investigator Benson, I'll restate my question. You testified earlier there was a chair, a heavy chair, on the balcony that was overturned. What does this show?
Overturned furniture means that there was an altercation that night.
And did you find any evidence as to why an altercation could have occurred?
Yes, I found that Roy Reynolds, the deceased, and a person by the contact name of Guy Rosling were trying to meet up that night.
Objection, Your Honor, speculation, as well as lack of foundation.
Your Honor, I'm about to lay the foundation for what the witness is testifying to.
The objection is sustained, subject to laying foundation.
Your Honor, may I ask that the testimony of the witness be stricken
The
from the record?
testimony she has given to this point is stricken, and
Thank
you may
you.
continue.
Investigator Benson, going back to the evidence you found at the medical examiner's office, what kinds of evidence did you find?
Yes, when I was at the medical examiner's, I found the cell phone of Roy Reynolds. It was not password protected, and the first thing open on the phone were some text messages. I analyzed these, took a screenshot, and used those as evidence.
Would you recognize these text messages if I showed them to you?
Yes, I would.
Let the record reflect I'm showing a copy to opposing counsel. Approaching the witness, Your Honor.
Yes.
Investigator Benson, are these the text messages that you took a screenshot of?
Yes, these are.
Do they appear to be a fair and accurate copy of those text messages?
Yes, they are.
Your Honor, at this time, the state moves to tender Exhibit C into evidence, the text messages between Guy Rosling and Roy Reynolds.
Objection to hearsay, Your Honor.
May I respond, Your Honor?
Yes.
These text messages are not hearsay because we are not offering them for the truth of the matter asserted. We are simply offering them to go to the effect that they had on Peyton Patterson. As Investigator Benson has testified, she was easily able to read these text messages, and since Rory Reynolds and Peyton Patterson lived in the same apartment and this phone was not password protected, Peyton Patterson had access to these text messages, and therefore they go to the effect that they had on Peyton.
Your Honor, if I may, there is no evidence or foundation that will be laid in the rest of this trial that Ms. Patterson did in fact see these text messages. If that is the case, opposing counsel cannot show that she did, and therefore it cannot be effect on listener.
May I respond, Your Honor?
Very briefly.
Yes, we are laying a foundation through Tracy Benson at this moment that these text messages were easily accessible. And Your Honor, even if you do find that they are hearsay, under Rule 703, it states that things that are hearsay are admissible under a witness if they are usually relied upon in their investigations. And since this cell phone was a piece of evidence that Tracy Benson relied upon in her investigation, then they are admissible under that as well.
The objection is sustained. I believe that you have still not properly laid a foundation. So I will ask the jury to ignore the last question and answer, and you may proceed.
Yes, Your Honor.
Yes, Your Honor. Investigator Benson, you said that you recognized Peyton Patterson in the back of a police car.
Objection leading, Your Honor.
Why don't you just rephrase your question?
Yes, Your Honor. Investigator Benson, do you see the person you recognized as Peyton Patterson in the courtroom today?
Yes, she's right here.
Let the record reflect that Tracy Benson has identified the defendant, Peyton Patterson.
Right.
Thank you. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Now, Investigator Beckett, before I go into my full cross-examination, I want to ask you about those Adirondack chairs that you investigated. So you said you walked out onto the balcony and you saw these heavy wooden chairs, or one of them, turned over on its side, right?
Correct.
And because you saw this one chair turned over on its side, you could reach the conclusion that there must have been a struggle that night. Is that what you're telling the jury today?
Yes, this chair could not have been knocked over by wind or any other natural means, meaning that there must have had to been some force to push that chair over.
So some force, and some force automatically equals a struggle. Is that what you're saying?
All the other indications that I've received in my line of investigation were what led me to eventually conclude that this overturned chair could be a sign of the struggle.
So it only could be a sign of a struggle. Is that right?
It could be a sign of the struggle, and it greatly indicates so based on my experience in forensic science.
All right, Investigator Benson, now I want to talk about the rest of your investigation. Now, when you arrived on the scene, I'm sure you were pretty concerned because there were so many people on the scene. It could have been contaminated, right?
No, the scene was just finishing being secured, and one of the first steps of securing a scene is making sure it's taped off and no evidence is tampered with.
Now, you would agree with me, you said the scene was buzzing with police officers, right?
Yes, there were a lot of police officers there were a lot of police officers there investigating.
And so it is your opinion that none of these police officers could have picked up or handled any of the evidence, is that right?
They would not have done so. They are qualified as police officers and possibly experts in their field.
Okay, but just to be clear, you were not there when all the other police officers arrived, were you?
No, I arrived 20 minutes later.
You do not know for 100% certainty that one of them didn't pick up an essential piece of
Objection, Your
evidence.
Honor. This is outside the scope of this witness's affidavit. She was not there in that time, and therefore this question asks her to speculate about things she does not have knowledge of.
Your Honor, the witness can say no to that question. That's exactly what I'm getting at, is that she does not know whether or not someone could have tampered with evidence prior to her arrival on the scene.
Objection overruled, and the witness will answer the question in whatever best way she can.
So you do not know, because you weren't there, whether or not some police officer or anybody really could have come in and picked up an essential piece of evidence, right?
I would not know since I was not there.
All right, Investigator Benson, now I want to talk about all the evidence you collected in this investigation. Now, first of all, you would agree with me that the evidence you collect is essential to your investigation, right?
Of course.
Every single little piece of evidence is very, very important, isn't that right?
Yes, and coming to a conclusion, I need to have all pieces of evidence that I can find at hand.
So that's why you, as an expert, have to be very thorough in everything you do, right?
Yes.
Okay, so I want to walk through all that thoroughness. Now, you started in the parking lot at the victim's body. Is that right?
Yes.
You took pictures of the victim's body, didn't you?
Correct. I took a lot of pictures that night. It was what I was instructed to do.
Okay, so you took at least a picture of the victim's body.
Yes, the crime scene.
You took a picture of the gun lying next to the victim's head.
Along with the shell casing, yes.
Along with the shell casing, right? You took a picture of the gym bag lying at her feet.
All of the items around her, yes.
The bloody gym towel.
Yes. That was included
The
in the
shoes.
items. Yes.
The shirt.
The shirt, the shorts. Yes.
And after you took all the pictures of these things, you went to the car right next to it. You took more pictures, right?
Yes, that was what I was instructed to do.
Did you take a picture of the outside and the inside of the car?
I believe so.
Take multiple pictures of both those things.
I took multiple pictures that night.
Okay, and once you finished taking a picture of the car and the body, you walked over to the condominium, right?
Yes.
I'm assuming you were taking pictures on the way, weren't you?
I was. I photographed the path to the condominium.
Okay, so you took a picture of the outside of the condominium?
No.
You didn't take a picture of the outside?
I just took it to the path of the condominium.
Okay, so you took a picture of the path to get to the outside of the condominium,
Correct.
right? Then when you got inside, you took a picture of the hallway,
Yes.
Stairwell.
All the rooms inside.
all the rooms inside. There were 6 rooms, isn't that right?
I believe so, yes.
6 individual rooms that you took pictures of, right?
Yes.
And once you finished taking pictures of those 6 individual rooms, you took pictures of more important evidence that you found in that condo, right?
Correct.
And that heavy Adirondack chair outside, you took a picture of that, didn't you?
I took a picture of the balcony.
Took a picture of the balcony, then you went inside. You took a picture of the phone you found on the counter, didn't you?
It was included in my picture of the kitchen.
Okay, it was included in your picture of kitchen. Did you take a picture of the beer cans you found in the trash can?
No, I just bagged and tagged those as evidence.
You just collected those as physical evidence, right?
Yes.
Physical important evidence, right?
I gave those to the crime lab for testing.
Okay, and when you finished with the condominium, you went to the medical examiner's office. Is that right?
Yes, to look for more evidence and examine the victim.
Okay, and at this final location, you took another picture of the victim's body, right?
Yes.
Did you take a picture of those 3 items you mentioned on direct examination?
No.
You didn't take a picture of those?
I did not. I just bagged and tagged those as evidence.
You collected more physical evidence, is that right?
Correct.
All right. Now, I just had my co-counsel here count all the pictures you just mentioned. You would agree with me that you probably took more pictures than I even counted in that cross-examination right there. Is that right?
Possibly so, but not the main points that I took photographs of were what I mentioned.
Okay, well, we counted 23. Now,
Yes, quite a lot.
Investigator Benson, out of those 23 different photographs, if I asked you to give me one of them today in court, could you do it?
It's not my job to supply the photos.
You do not have any of them in court today. Is that what you're telling me?
I physically don't have them. I don't know if the state does.
You don't know if the prosecutors have those photographs?
It's not my job to know if the photos are in court.
But all that important evidence, you don't have any of the photographs you took from that night, do you?
No, I put them in an investigation file and handed them to the proper officers.
Investigator Benson, if I wanted you to show this jury one of those photographs, you couldn't do it, could you?
I wouldn't know if there is one supplied in court.
Now, Investigator Benson, we talked a lot about the photographs you took on June 18th, 2018. That was the night of the incident, right?
Yes, it was.
Now, we do have one photograph, and that was a photograph you took the next day.
Yes.
And that was a photograph of the parking lot, is that right?
Yes, it was quite dark that night, so I needed to make sure that the photograph was accurate and light enough that you could see anything.
And the reason you needed to take a picture of this parking lot is because it was a dangerous parking lot, right?
Sure, it was quite dangerous.
You yourself tripped and fell multiple times, is that correct?
I did.
Now, Your Honor, may I approach the witness?
Yes.
Let the
I
record
ask that I
reflect
see a
I'm
copy,
showing
Your Honor.
opposing counsel a clear and unmarked copy of Exhibit A and giving the witness the same document. Do you recognize this picture?
Yes, I did. This is the photo I took the next day when taking the photo of the parking lot.
Is it an accurate picture of the parking lot?
Of that one section in the parking lot. I took this to capture the most specific and worst elements of this parking lot, and that's what it's shown in this exhibit.
Your Honor, we offer that evidence was been pre-marked as Exhibit A.
No objection, Your Honor.
At this time, may I have co-counsel assist me in setting up an enlargement?
Yes, you may. And for the record, that is
I ask
marked
that
and
I be
admitted.
Sorry, Your Honor. I ask that I be able to move in order to see the demonstrative more clearly.
Yes, you may.
Thank you, Your Honor.
Can the members of the jury see? Investigator Benson, is this that photograph?
Yes, it is.
Now, I want to go through this photograph. You described the parking lot as very dangerous, right?
Quite dangerous, yes.
You said there were multiple potholes, more like this potholes all across the parking lot. Is that right?
They were scattered and quite bad. in
So
some
there was
places,
more than just this one, correct?
Yes, there you could see one in the top section. It's quite small.
There's
that
another one right here, and there's cracks, and the parking lot is crumbling apart. Is that right?
It was in quite bad shape, but there's a lot of parking lots in bad shape these days.
Now, when you were walking in that parking lot, it was dark, wasn't it?
Yes.
It was hard for you to even navigate across the parking lot without falling, wasn't it?
I had never been to the scene before, so I
But
wouldn't
there were
know.
police lights there, weren't there? So you could see at least better than it being pitch black, right?
They were all surrounding the crime scene at hand, not outside in the path of the condominium.
Okay, but you would agree with me that for you, in the dark, it was difficult for you to even make it across this parking lot to get to the crime scene without spraining your ankle, isn't that right?
Oh, the ankle, it's always been weak since 5th grade soccer. It's a wonder that I'm in heels today, but
Well, that wasn't my question. It was difficult for you to walk across that parking lot that night, wasn't it?
it was difficult, yes, but I was able to.
No further questions, Your Honor.
Thank you. Is there time for redirect? I'll ask first. Yes. Is there redirect examination?
Yes, Your Honor.
Okay.
Investigator Benson, when you tripped in that parking lot, were you concerned that your firearm would accidentally discharge?
No, of course not.
Objection on irrelevance.
May I respond, Your Honor?
Yes.
This is extremely relevant in the case at hand today, as one of the defense's main points is that Peyton Patterson tripped in that parking lot. And she, like Investigator Benson, is trained in how to handle firearms. And Investigator Benson's gun did not discharge when she tripped, and therefore is extremely relevant in the case at hand today.
I'm going to sustain the objection. There's no proof yet in the record that the guns are similar, and until we can see why it would be relevant based on similarities, I will ask the jury to disregard that last question and answer, and you may proceed.
Your Honor.
Yes, Your Honor. Investigator Benson, why was it difficult for you to navigate this parking lot?
It was in some bad condition.
Had you ever been to this parking lot before?
No.
Thank you, Your Honor. No further questions.
Thank you.
No recross, Your Honor.
All right, thank you. Investigator, you may step down.
Thank you.
You may call your next witness.
Yes, Your Honor. The state calls Andy Anderson to the stand.
Ms. Anderson, you may be seated, and I'll just ask you to recall that you have been sworn and are under oath as you testify.
Yes, Your Honor.
Hello, Miss Anderson. Will you please introduce yourself to the jury?
Hey, my name's Andy Anderson.
Where do you live?
I have lived in Crater County for some time now. I have a chill spot down by the river. It's a condo.
What do you do for a living?
I'm so glad you asked. I'm all about connecting the mind, body, and spirit. So when all the chakras aligned and the gods smiled down upon me.
Object to relevance.
May I respond, Your Honor?
Yes.
This is relevant because Miss Anderson is laying some background as to who she is, which is important in understanding her testimony. Furthermore, Your Honor, if Ms. Siebel will allow my witness to finish, you will learn that it's through her job that she met the defendant and Rory, who are...
All right. I'm going to give you some leeway and allow you to continue. But if you cannot link up the relevance at the end of that, then I would entertain the objection again. At this time, it's overruled.
Yes, Your Honor. So will you tell us about your job and how it relates to Rory and Peyton?
Well, as I was saying, when Mother Nature led me to get this wonderful part-time job at a local tea and incense shop, and that's how I met Peyton and Rory.
I want to talk about that for a bit. What was your relationship like with these two girls?
We all got along pretty well, you know, it was love and light all around. We actually got pretty close because they ended up moving into the condo right above me. But after graduation, Peyton stopped coming around the store and things just seemed different.
What do you mean things seem different?
I always tried to make conversation with her whenever I passed her in the lobby or even when we were in the elevator together, but she was always very short and unresponsive. It felt super dismissive. Dudes, she was totally harshing my vibe. I mean, talk about #awkward elevator rides.
Now, Miss Anderson, you mentioned that you were neighbors with Rory and Peyton. Did you observe them ever fight?
Well, around 2 to 3 times a week, they would get incredibly loud and noisy.
Your Honor, improper character evidence.
May I respond, Your Honor?
Yes.
This isn't improper character evidence because we're not offering this to show that because they fought in the past, they were going to fight in the future. Rather, we're offering this to show that because they fought a lot, that's why Miss Anderson didn't go and intervene on the night of the incident. We're not offering this for character evidence.
May I respond, Your Honor?
Yes.
Well, in that case, if this is character evidence being offered for non-propensity purposes, then under Rule 404B, we must conduct a jury out hearing in order to establish the probative value of this testimony today. And I would ask that we conduct that hearing now.
All right. I believe then that an out-of-jury presence hearing has been requested, and as I have ruled earlier, you may conduct that now briefly, and we will treat this, and jury, you are not to consider anything that you're not going to hear now until it has been ruled admissible or inadmissible.
Yes, Your Honor.
Okay.
Once again, Your Honor. Oh, so,
Yes.
yes.
So go ahead and ask the questions that you want in, and then we'll have further discussion.
Yes, Your Honor. So, did you observe Miss Peyton, the defendant, and Rory ever fight?
Around 2 to 3 times a week, they would get very loud and noisy into the night.
Now, Ms. Anderson, I want to turn your attention.
Objection, Your Honor. I don't believe that she actually responded to that last question. She asked if she was fighting, and she responded with, they were being loud and rowdy. That in no way indicates fighting.
May I
Yes.
Getting loud and rowdy are describe what fighting
All
is
right.
normally
Is
like.
that the extent of her testimony? Is that what she's going to say?
Yes, Your
We
Honor.
don't want to conduct a full trial within a trial here, so we need to get to what you intend to offer, and then we can rule on it. So that's what you are intending to offer.
Yes, Your Honor.
All
That's
right. Then we'll continue, and I'll make a ruling after I've heard from everybody at the end.
Yes, Your Honor.
Now, Ms. Anderson, I want to turn your attention to June 18th, the night of the incident. What were you doing around that time?
Your Honor, did we conclude the jury out hearing, or may I ask a couple questions
No,
as contrary
you may.
proof?
We have not concluded the jury out hearing. Is that part of what you need
Yes,
us to know?
that is the extent of her testimony about them
Okay.
fighting.
All right, thank you. I should have asked that question. I apologize. Then you may ask questions.
Miss Anderson, you never heard them actually arguing, did you?
I just heard a lot of yelling from upstairs.
But in no way did you ever indicate that these bouts of yelling were actually arguing or even directed at each other, did you?
Well, no, I just figured they were watching sports, except it was very loud and seemed really bad.
Thank you, Your Honor, that's all.
All right. The objection is overruled, and I'm going to permit her to answer, assuming that she will answer the question the same way again. But I'm directing counsel and the witness not to speculate or to talk about what it might have meant, but simply to answer the questions about what you heard or observed.
Yes, Your Honor.
And now the jury out hearing is concluded, and you may continue with this witness.
Yes, Your Honor. Miss Anderson, did you observe Peyton and Rory ever get loud or fight?
Yes, around 2 to 3 times a week they would get incredibly loud and noisy. I mean, it really messed with my meditation.
Now, I want to turn your attention to June 18th, the night of the incident. What were you doing around that time?
I remember that it was a Monday night because that's when my favorite show, The Singer, is on. I love that show. Never miss an episode. Sometimes I sing along, but other times I just let them sing me into a deep sleep. And
Sustained. Counsel, I know you were trying to ask to the point questions. If you'll continue to do that and continue with your line of questioning.
Yes, Your Honor. Now, Miss Anderson, without telling us about what was on TV, will you tell us what you were doing around the time when this incident occurred?
well, while I was watching TV, I heard yelling coming from upstairs.
Did you try to investigate to find out what that was all about?
No, it happened so often that I didn't really think much of it.
Now, Miss Anderson, what happened next?
Well, that night I was still watching my show, and then that's when all of a sudden I heard this loud pop. And at first I thought it was fireworks, so I went to go look out the window, and although it seemed a bit too early to be celebrating the 4th of July, who am I to miss a fireworks show? But when I went to go look out the window, that's when I realized it was not fireworks.
What do you mean?
I couldn't really see much since the street light near my condo is out, but I was able to make out a figure in the parking lot standing next to a car with what looked like a bag near their feet. At first, I thought someone was trying to snatch Rory's car, so I figured I'd call her and let her know what was happening. I guess I didn't realize what happened to her.
Miss Anderson, you just testified that you weren't able to get a hold of Rory, but were you able to get into contact with the defendant?
Well, here's the funny thing. When I called Rory, it rang and rang and rang and then went to voicemail. But then I tried to call Peyton and it rang once and then went straight to voicemail. Then I figured I'd call the police.
Counsel?
May I respond, Your Honor?
Yes.
This is relevant because we're establishing background as to what she did, who she called, and who she called after. And if you allow me to continue with my line of questioning, if my witness is allowed to finish her answer, you will learn that she proceeded to call the police right after. This is relevant. She's merely just stating who she called.
May I respond, Your Honor?
Yes.
I'm okay with her testifying as to who she she called, but the contents of those calls, how many times it rang, that just confuses the jury, and it's in no way relevant or probative.
I'm going to sustain the objection in part. You may continue your line of questioning and establish that which you are seeking to establish, but I ask the witness to answer directly only the things that are asked in the question. Do you understand?
Yes, Your Honor.
Thank you.
And Your Honor, I would ask that any testimony as to this would be stricken.
Yes.
Now, Ms. Anderson, who did you call after you called the defendant and Rory?
Well, I figured I'd call the police and let them know what was happening, and I gave them the address, and they arrived a few moments later.
And what happened after the police arrived?
I figured I would go down in the parking lot and tell them exactly what I saw. And when I got down there, that's when I realized this was way more than someone just trying to steal a car.
Oh, Ms. Anderson, I know that this scene was a lot to take in, but did you ever learn what happened?
I learned about this crazy event that occurred between Payne and Rory in that parking lot, and about everything that went down, and I didn't really know how to respond.
Ms. Anderson, did you observe anything else about your surroundings?
Well, I was looking around, trying to gather my thoughts, and that's when I found this weird postcard.
Would you tell the jury what postcard you're referring to?
Well, it had orange trees on it and a mountain in the background.
And would you recognize this postcard if I showed it to you today?
Yes, I would.
Permission to approach the witness with what has been previously marked as Exhibit
Yes.
B?
Has opposing counsel seen it?
Yes, I will show a copy to opposing counsel. Oh, I need it. Ms. Anderson, do you recognize what I've just handed to you?
Yes, this is the postcard found at the crime scene.
And is it a fair and accurate copy of this postcard?
I would say it is.
At this moment, Your Honor, the state moves to enter Exhibit B, the postcard that Ms. Anderson found, into evidence.
Exhibit B is admitted into evidence.
Your Honor, first of all, I object to hearsay as to this evidence being admitted.
All right, well, go ahead and make your argument then.
Your Honor, they're offering these statements within this postcard for the truth of the matter asserted. It's a statement made out of court, offered in court, therefore it's inadmissible.
May I respond, Your Honor?
Yes.
First of all, would you like a copy before?
You can assume that I have a copy.
Yes, Your
Thank you.
Honor. This is not hearsay because we're not offering this for the truth of the matter asserted. This postcard says things like Southern California, or 1 year ago we were together here. And Your Honor, we're not offering that for the truth of the matter asserted. Rather, we're offering it to show that the defendant could have interpreted it as actually them being together, them being Guy and Rory, getting angry and thus going toward motive. We're not offering this for the truth of the matter. Therefore, this is not hearsay.
May I respond, Your Honor? None of that foundation has been laid. We have no way of knowing whether the defendant even saw this postcard that night. And until that foundation has been laid, this evidence is inadmissible.
May I respond, Your Honor?
No, I think that's enough. The objection is sustained at this time. A foundation has not been laid. You may continue to ask.
Yes, Your Honor. Now, Ms. Anderson, without testifying to the contents, what is written on this postcard, will you describe the image that you see?
Right, it has obviously oranges on it, and
Objection, Your Honor, relevance.
May I respond, Your Honor?
Yes.
This is relevant because it goes to show that the defendant will later testify to seeing this postcard. And Your Honor, we're simply offering this to show that this postcard, which was in the apartment, somehow was transmitted all the way from there to the parking lot. Ms. Anderson found this postcard in the parking lot, and therefore even more foundation will be laid when the defendant comes up here and testifies that she did in fact see this postcard.
Your Honor,
Yes.
respectfully, counsel has no way of knowing as to what the defendant will testify to, or even that the defendant will testify at all today.
May.
All right. The objection is sustained at this time. We all understand that this has been pre-marked as Exhibit B, and we will await any other testimony that may come about it. I don't think this witness has to try to describe it when apparently it itself, we understand what it is. So at this time, it's still not admissible. And the jury has not yet had a chance to see it, but you may continue questioning any witness to further lay your foundation.
Yes, Your Honor.
Yes, Your Honor. Now, Ms. Anderson, I know that this might be hard to talk about, but did you ever find out what happened?
I learned that my good friend and neighbor, poor Rory, was
Objection, Your
gone.
Honor, hearsay.
May I respond, Your Honor?
Yes?
This is not hearsay because this is not an out-of-court statement being offered for the truth of the matter asserted. Furthermore, Your Honor, it's not in dispute today that Rory is deceased. Ms. Anderson went down to the parking lot, and when she saw everything that happened, when she saw, blood and all these different things, that is not a normal circumstance, and that was not a normal condition of the parking lot. It's safe to assume that she realized that something was off. Therefore, this is not hearsay. We're not offering this for the truth of the matter asserted.
Then in that case, Your Honor, I would change my objection to relevance. If it's not being offered for the truth of the matter asserted, then I don't understand how her knowing whether or not Rory Reynolds was shot is even relevant at all in today's case.
Objection is overruled, and of course you may cross about this if you see fit later.
Yes, Your Honor.
Yes, Ms. Anderson. So, will you tell us what happened on that night, what you believe happened?
That one of my very dear and close friends is now dead, and however, Rory will always remain alive within our hearts. Truly a pure soul gone too soon.
No further questions at this time, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Ms. Anderson, you testified on direct examination that you heard the defendant and Rory Reynolds being loud with each other often in the apartment above you, correct?
Yes, they got very loud and noisy into the night and really disrupted some of my nights, I guess.
But just so this jury understands perfectly clearly, you couldn't even say that they were arguing, could you?
I don't really know what the yelling was about. Sometimes I just assumed that they were watching sports or yelling at the TV, but there's obviously many different reasons that they could have been fighting.
In fact, that's what you thought it was that night. You thought that they were just yelling at sports on the TV, didn't you?
Yes, I did.
And you thought that this was nothing new, correct?
No, nothing new.
Now, another thing that happened on the night of June 18th was you heard a pop, correct?
Yes, I heard a very, very loud pop from outside.
Just to be clear, you don't know what was happening outside before this pop, do you?
No, I wasn't outside before I heard the pop.
You don't even know what happened right after that pop, do you? Until you ran over to that window, correct?
Yes, I found out what was going on or I saw what happened after I went to go look out the window.
And even when you did look out the window, you couldn't see much of anything all because the street light was out, correct?
Yes, personally, I find it a lot more convenient because otherwise it just glares right through my window and it's really bad for my meditation.
Well, thank you. So that was a yes to my question.
What was your question, please?
That it was so dark that you couldn't see, correct? Because the street light was out?
Yes.
And furthermore, it was just pitch black and you couldn't see anything at all, right?
I couldn't really see much, but I was able to make out the parking lot and a little bit of the stuff going on.
Now, Miss Anderson, if what was most important for this jury to understand today was what happened in the 3 seconds before that gun went off, you couldn't tell us, could you?
I could see the figure just standing there next to the
That was
car.
after the pop, right?
Yes, it was after.
No further questions.
Is there a redirect?
No redirect, Your Honor.
All right. Thank you. You may step down. Prosecution may call its next witness.
The state calls Dr. Wimberly to the stand.
Dr. Wimberly?
And before I begin, Your Honor, permission to set up a demonstrative with the exhibits facing away from the jury.
Yes, you may do that.
Thank you.
Dr. Wimberly, I'll just remind you that you've previously been sworn and you're under oath as you testify.
Yes, Your Honor.
Your Honor, before we get more into this, when these exhibits are shown, could I go ahead and move once they're shown?
Yeah, absolutely.
All right.
Please introduce yourself to the jury.
Hello, everyone. My name is Dr. Sam Wimberley.
And what is your occupation?
I'm the medical examiner and coroner right here in Crater County, and have been for quite some time.
What does your job entail?
Well, I examine the bodies of our Crater County residents to determine the circumstances surrounding their deaths as well as the cause of their death. You see, each body I encounter is like a story, and it's my job to unravel that story. It's quite fascinating.
How do you go about doing that, Doctor?
I always examine two things in my investigation. First, I do a standard examination of the body, and second, I review the crime scene investigation file from the Crater County Police Department, as that often serves as a very important piece of the puzzle.
And do you use this file when determining the circumstantial cause of death in your victims?
Oh yes, it is crucial to finding the truth in my investigation. I often look through it for things like eyewitness statements or other things of that sort that could be of use to me.
Tell us about your education, Doctor.
Well, I went to medical school and did my residency, and then I came to the States to do my medical examination fellowship at Boston General.
Can you tell us a little bit more about how much experience you have in crime scene investigation and gunshot wound examination?
Yes, I've actually been recognized for my work in a gunshot and crime scene investigation and examination. I've been nominated for the prestigious award of a Medical Examiner Fellow of the Year for Crime Scene and Gunshot Investigation and Examination. Only 5 people are nominated for this award every year, so I'm quite humbled that my hard work and education have been paying off. And I've joined Detective Beckett on several of her crime scene investigations to know this field in even greater detail as I use it in my daily work.
At this time, Your Honor, the state tenders Dr. Wimberley as an expert of medical examination and pathology to include reliance on crime scene investigation and gunshot wound examination files.
There's no objection.
All right. Then Dr. Wimberley is accepted as an expert in those fields and may testify, including giving opinions if necessary.
Yes, Your Honor. Now, Dr. Wimberley, I want to switch gears. How are you involved in today's case?
This past June, the victim's body, Rory Reynolds, was delivered to my morgue, and I was tasked with determining her cause of death.
And how did you go about examining the body?
Well, I completed my 4-point examination method.
What did you do first?
First, of course, I did a standard examination of the body. And in the case of Rory Reynolds, I found deep lacerations and contusions, which are cuts and bruises, on various parts of the victim's body.
Your Honor, permission for Dr. Wimberley to stand within the witness box, not to step out, simply stand within, so that she can more clearly demonstrate to the jury where these bruising and lacerations were found on the victim's body.
Any objection?
There's no objection.
Dr. Wimberley, you may stand and remain within the witness box.
Now, Dr. Wimberley, can you walk us through your findings?
Yes, so the first thing that I noticed in my examination of Rory Reynolds' body were the lacerations and contusions on both sides of the face. Then I found lacerations, but without contusions, on the right shoulder and right hand. Then I found contusions on the right forearm. And after that, I located where the bullet was lodged.
And what did you find next?
Then I found that the bullet was lodged in the right occipital lobe region of the brain, which is right back here. And I found that it was faced towards the rear of the brain. And after that, I noticed there was severe brain swelling and hemorrhaging in that area as well.
You may be seated, Dr. Wimberley. And what did you find next in your investigation of Rory Reynolds' body?
After that, I tested for the victim's blood alcohol content and found that it was only 0.02, which is well below the legal limit to drive of 0.08 here in the States. So I determined that the victim was not impaired when the incident occurred.
And what did you find next in your investigation?
After my full standard examination of the body, I waited on the crime scene investigation file from Detective Beckett. And once I received that, I reviewed it in great detail and used it for my investigation.
Now, Dr. Wimberley, what specifically did you focus on within this file from Detective Beckett?
Well, in this particular case, I found an eyewitness statement, which I often use to my advantage in finding the facts about the investigation and examination. And with this, I found an eyewitness statement from Peyton Patterson.
Dr. Wimberly, tell us more about how you use the defendant's eyewitness statement when determining the circumstantial cause of death.
Yes, so with the eyewitness statement of Peyton Patterson, I found that there were consistencies with what I had found in my examination of the body and the concrete evidence, but I also found inconsistencies, which can serve as very important clues as well.
Your Honor, permission to approach the witness with what has been previously marked as Exhibit E.
All right, you may. Have you shown counsel?
Let the record reflect I'm showing a copy to opposing counsel.
Thank you.
Do you recognize this document, Dr. Wimberly?
Yes, this is the eyewitness statement of Peyton Patterson that I reviewed.
And does it appear to be a clear and accurate copy?
Yes, it appears so.
Your Honor, at this time, the state enters Exhibit E into evidence.
No objection.
All right, Exhibit E is now entered into evidence and may be considered. You may
Permission
continue.
to display demonstrative and for Dr. Wimberly to step down and walk the jury through her findings more clearly?
Yes, and counsel, you certainly may step around now.
Now, Dr. Wimberly, will you walk us through those findings?
Yes, so the first thing that I noticed when I reviewed the eyewitness statement of Peyton Patterson was that I could confirm that Peyton Patterson was in fact the person that shot the bullet that killed the victim. And there were 5 parts of this statement that led me to that conclusion. Here, you see, when I got my gun out of the car. Second, I just squeezed the trigger. Third, the gun went off. 4, I shot Rory. And 5, I saw the body lying on the ground.
Thank you, Dr. Wimberly. You may be seated. Now, were you able to conclude the ultimate cause of death of Rory Reynolds?
Yes, the ultimate cause of death of the victim was the resulting brain swelling and hemorrhaging that resulted from the gunshot wound to the head.
And were you able to memorialize these conclusions in any type of report?
Yes, I created an autopsy report that details all of my findings.
Your Honor, permission to approach the witness with what has been previously marked as Exhibit D.
Yes.
Let the record reflect I'm showing a copy to opposing counsel. Do you recognize this document?
Yes, this is the autopsy report that I created for Rory Reynolds.
Your Honor, at this time, the state enters Exhibit D into evidence.
No objection.
Exhibit D is now entered into evidence.
Permission to display a demonstrative, Your Honor.
Yes, and counsel, you may come back around.
And permission for Dr. Wimberly to step down.
Yes.
Now, Dr. Wimberly, we're looking at your official autopsy report here. Can you walk the jury through your ultimate conclusions?
Yes, so in my autopsy report, I always start with a background on the victim. So you see here, gunshot wound to the head outside of the patient's residential address, a 24-year-old white female. And then next I talk about how I recovered the bullet from the brain and the brain swelling and hemorrhaging present in that area as well. Then I go on to talk about the lacerations and bruising and the BAC of .02. And then at the very end, I give my final conclusion after my full examination and investigation. And in this case, after reviewing both the examination of the body and the facts that I found in that, and the facts that I found and the inconsistencies that I found in the eyewitness statement of Patient Patterson, I concluded that this crime was committed in a homicidal nature.
Thank you, Your Honor. No further questions at this time.
All right. Dr. Wimberly, you may sit unless counsel needs you to stay there. And,
All right.
Are you using this?
Actually, I could use it if you would leave it up. You can go ahead and resume your seat. Dr. Winway, I'm going to do something that I don't usually do on cross. I'm going to ask an open-ended question. Let's say I'm the best medical examiner in the world, the best one. You seem to have a British accent. You're probably from Britain. You're a different part of the world. The best one in the world. And I see a body on the ground that's been shot. That's all I know. I do the autopsy. I measure the organs. I see the vitals. I notice with cause of death, what caused them to die.
Objection, Your Honor. Counsel is testifying, and I don't see a question coming anywhere soon.
Or I'm just providing a hypothetical to give to this witness to ask a question.
Counsel may continue with the hypothetical, and I'm sure you will get to the end as soon as you've included all your facts. You
Yes,
may
Your Honor.
proceed.
All right, let's say I have that body. I perform the autopsy. I get all the information I need for the cause of death, what caused that person to die. And then I rule a manner of death, homicide. Can I do that?
Yes, that is part of my job, to determine why the decedent died. And that is why that I also review the crime scene investigation file. And it serves as a very important piece of the puzzle. I put that together with my examination of the body, to find the truth.
So it's important that you review the crime scene investigation file.
Yes, it is.
Just to be clear, you did your autopsy 2 days after the incident, right?
Yes, you see, I learned of Roy Reynolds' death the morning that I walked into work on the 19th. And I had, according to standard procedure, I had to do the autopsies in the order that the bodies came into the morgue. So I had 4 bodies that I had to do before I got to Roy Reynolds. And it was very late that night that I got to her.
You performed the examination on June 20th.
Oh, no, I performed it very late on the 19th. It was very close to midnight. So you see, on the autopsy, it's dated the 20th.
All right, around that time. But you did not include the manner of death until 2 months later, right?
No, I did not. It was a particular case, as I was waiting on the crime scene investigation file from Detective Beckett, as I cannot officially complete and submit my report until I've received that information.
That's pretty interesting, because we were looking at that report earlier. Let the record reflect how constructing an enlargement of the autopsy report that we saw earlier, which been pre-marked Exhibit D, opposing counsels can come forward. Here, I'm going to angle this a little bit that way. Can you see that date right there? Here, I'll go ahead and read to you. That's June 20th, right?
Yes, it is.
6/20/2018.
Yes, that is when I've stated that it was officially dated. However, I did perform the autopsy very late on the 19th.
Now, just before I ask the next question, I'm making sure the jury has the timeline right. You performed this just a few days, just right after the incident, but you didn't get to the manner of death, whether it was homicide or not, until 2 months later, right?
Yes, you see, as it is Detective Beckett's responsibility to send me that crime scene investigation file, and I waited on it, and after I received it, I reviewed all the evidence again and put it all together after I had all of the necessary information to make my final conclusion.
All right, so I'm going to read this, and you tell me if I read this correctly. Based on my investigation and examination, it is my belief that the gunshot wound was by another person was homicidal in nature. That's a manner of death, isn't it?
Yes, that is correct. That is part of my
That
job.
you reached on the 20th of June,
Yes,
only 2 days after this autopsy was performed.
yes.
You did not have the appropriate materials from Detective Beckett, did you?
No, I did not. Not at that time.
You reached a conclusion that it was homicide 2 months before you received any information from law enforcement.
Yes, you see, after I performed my examination of the body and I found those deep lacerations and contusions on various parts of the victim's body, I made that hypothetical conclusion. And after I reviewed the crime scene investigation file, just writing out my autopsy, after that I found that I did not need to change it. As sometimes after I review the crime scene investigation file, I change it because I may need to change my final conclusion.
Let me get this straight. Let's make sure the jury gets this straight. You can have a body, and all it has is a gunshot wound, which is what we had with just the autopsy. And you can conclude just from that it was a homicide?
Well, yes, you see, it's been my standard practice for a very long time now in this line of work. And with the severity of the lacerations and contusions, I determined that there was a physical altercation that occurred that night. So that was my hypothetical conclusion at first, and I found with Patient Patterson's eyewitness statement that it could remain the same.
So you can conclude, just from a gunshot, you can rule out accident and claim that it's a homicide, just from a gunshot.
Oh, no, not just from a gunshot. From my full examination of the body, you see, I found those lacerations and contusions on both sides of the face, on the shoulder, hand, and right forearm.
You have no idea where those lacerations came from, do you?
Oh, it is part of my job to make my expert opinion as to where they did come from.
Did you give any opinion on where they came from?
No, I did not. You see, in my autopsy, it is just standard that I give a simple, succinct, final conclusion at the end. I do not provide any details about my conclusion. I mostly provide facts and give a one-sentence final conclusion.
So you have no idea what caused that bruising, do you?
Well, yes, I do have an idea.
Another open-ended question. What on earth caused that bruising?
Well, you see, after my full investigation and examination of the crime scene investigation file and my examination of the body, I found that it was from a physical altercation.
A physical altercation, meaning something had to touch the body?
Yes, you
Something.
see...
You don't know what?
No, I do not
You don't know when?
No, I do not know.
So you have
when
no idea what
exactly.
caused those lacerations and bruisings, do you?
Well, I do know that they must have been caused by another person, as the severity of those lacerations and bruising was not just because of a natural incident.
No, you do not know that. You just testified that you have no idea what caused those bruisings.
No, I did not. I can make a expert opinion on the fact that, yes, it was caused by some other person and not just a natural cause, as they were severe, deep lacerations and contusions on the victim's body.
Understand that bruises don't just appear on a body, they have to be put there.
Yes, they do.
But you don't know what put them there.
Objection, Your Honor. This is asked and answered. This question has been asked multiple times, and Dr. Wimberly has given a consistent answer each time.
The answer has been consistently confusing. I'm just trying to clarify it.
Then you may ask one more time.
Yes, Your Honor.
Yes, Your Honor.
All right. I'll ask the question one more time. You have no idea what caused these bruises.
Yes, I can make an expert opinion that it was, in fact, from another person, as they were not naturally caused. You see, I've been in this line of work for quite a while now, and I can recognize when lacerations and contusions are from merely a fall or from somebody else causing them and inflicting them on the victim.
All right, let's go back to the hypothetical. I'm, again, the best medical examiner in the world, and I hit my arm as hard as I can against this rail. Is it going to bruise?
Yes.
Thank you. Nothing further.
Thank you. Is there redirect?
Briefly, Your Honor.
All right.
Dr. Wimberly, can you walk us through these bruising and lacerations and what final conclusions you came to about them?
Yes. So you see, the very first thing that I noticed in my examination of the body were the deep lacerations and contusions, the cuts, the deep cuts and bruises that I found on the victim's body, on various parts of the victim's body. And you see, after my full, final examination and investigation, I found that these were signs of a physical altercation that occurred that night.
And how did this eyewitness statement play into that?
You see, in the eyewitness statement, it says, Patient Patterson states that there was a fight, which happens sometimes. Now, yes, that was what the fight was consistent with the evidence that I found on the victim's body. But I don't know about you. I would hope that a fight that happens sometimes does not end up in a physical altercation.
Thank you, Your Honor. No further questions.
All right.
Recall?
Very briefly.
Yes. Going back to the timeline, Dr. Wimberly, you mentioned the eyewitness statement, which again you received 2 months later, right?
Yes, I did.
And the autopsy report in which you concluded the manner of death was written only 2 days after.
Yes, again, I made that hypothetical conclusion, willing and very ready to change it if I found anything contradicting the evidence that I found on the examination of the body. And that is my standard practice. After I reviewed the full crime scene investigation file, I learned that it was not necessary to change it. I definitely would have if I needed to.
Thank you. Nothing further.
Thank you. You may step down. Counsel, do you have any further evidence to present?
No, Your Honor, the state rests.
All right. Thank you. Vince, are you ready to proceed?
Yes, Your Honor. At this time, we call Francis Franklin to the stand.
All right. Francis Franklin will come forward and we'll be sure everything else is in its place. Ms. Franklin, I ask you to acknowledge that you understand you have previously been sworn and you will testify under oath.
Yes, Your Honor.
May I proceed, Your Honor?
Yes.
Please tell us your name.
My name is Francis Franklin.
Ms. Franklin, what do you do for a living?
I am a correctional officer at Lawnay Correctional Complex in downtown Crater County.
Ms. Franklin, before I continue on, it's very important that the jury hears exactly what you're saying. This is a big courtroom. I understand it's hard, but would you mind speaking up a little bit so they can hear you? Ms. Franklin, where do you live in Crater County?
I live in the Cumberland condos, which is in downtown Crater County.
How long have you lived in these Cumberland condos?
I've lived there for about a year and a half.
So did you live there on June 18th, 2018?
Yes,
Do you remember if you were home that day?
I do remember. I remember everything about that day and everything that happened, and I remember very clearly that I was home.
Now, before we talk about what happened that day, I want to talk to you about your relationship with Miss Patterson. First of all, do you know Miss Patterson?
I do.
How do you know her?
Well, Peyton and I met when we were really young. We went to school together, elementary through high school, and even though we lost connection for a couple years when I moved away from my hometown, we really reconnected because she moved into the Cumberland condominiums just a couple years ago.
How would you describe your relationship with Miss Patterson?
I would say we're very good friends. I mean, we hang out often and we really enjoy each other's company.
Ms. Franklin, you also just testified that Ms. Patterson moved into the same condominium as you. Did you know her roommate, Rory Reynolds?
I did. I didn't know Rory super well, but because she was roommates with Peyton, I did know her.
Could you please describe Peyton Patterson and Rory Reynolds' relationship based on your observations of it?
Well, from what I could tell, they were...
This is speculation.
Your Honor, the witness has not even been allowed to say what she was about to say. My question specifically asked for her to give her observations of that relationship, which is a rationally based perception in that case.
I'll overrule the objection at this time, allow you to re-ask your question. If you hear anything in the answer that you think continues to be objectionable, you may make the objection again.
Yes, Your Honor.
So, Ms. Franklin, one more time. Based on your own observations of that relationship, how would you describe it?
Well, from what I could tell, the two of them were very close. I mean, they did get into little arguments from time to time, just like any good friends do, but overall, they were really good friends.
Ms. Franklin, now I want to talk about what happened on June 18th, 2018. Now, you already testified that you were home that day. Mm-hmm. When did your interactions begin with Ms. Patterson?
Sometime in the mid-afternoon, I invited Peyton over to hang out at my condo.
What did you do when Ms. Patterson came over to your condo that night?
For most of the time, we just listened to music and played video games.
Now, Ms. Franklin, I anticipate opposing counsel is about to cross-examine you on this. So just to be upfront with the jury, did you or Ms. Patterson ingest any illegal intoxicants or drugs during the time she was over at your condo?
While she was at my condo, Peyton did smoke a spliff cigarette.
Just to be clear, could you describe exactly what you mean by a spliff cigarette?
It's like a 50-50 with tobacco and marijuana.
And also to be clear, did you smoke one?
I didn't.
Thank you. Now, how long did Ms. Patterson stay at your condominium that night?
She was there for a couple of hours.
What did you do after she left?
After she left, I just watched TV for a couple hours until I guess it was about 9:30 that I walked out on my balcony to get some fresh air.
And Ms. Franklin, the next few things are very important, so make sure you speak clearly so the jury can understand. What did you see from the balcony that night?
Well, when I was out on my balcony, the very first thing that I noticed was that Peyton was down at Rory Reynolds' car.
Was this in the parking lot?
Yes.
Now, we've heard a little bit about that parking lot today. You live there. How would you describe it?
The parking lot is in terrible condition. I mean, there are potholes everywhere, and it's uneven, and it's very rocky.
Now, you said Ms. Patterson was in this parking lot. Could you see what she was doing?
I could.
Would you be able to more accurately describe to the jury and show the jury what she was doing if you could step down the well and kind of lay out the scene for them?
Sure.
Your Honor, may the witness take leave of the stand and step into the well of the court?
Yes, you may. Counsel, if you wish to come around, you may as well.
Ms. Franklin, if you would, just step down into the well of the court here, and I'm going to ask you a few questions. And as I ask you these questions, just please demonstrate to the jury exactly what was happening in the parking lot that night. Now, from your viewpoint, from the balcony, what did you see?
Well, if you want me to demonstrate, if the car is about right here, this being the driver and this being the passenger side, Peyton was at the trunk of the car and the trunk was open. And it looked like she was getting some stuff out of the car. And she had her hands full of all this stuff, and then she turned to walk away from the car. But it looked like something got stuck, and like she was trying to like pull something loose.
What happened next?
Well, when she was in the middle of struggling with this thing, that's when I heard a gunshot go off. And the very first thing that I saw when I heard the gunshot go off was someone on the passenger side of the car just collapsed to the ground.
Ms. Franklin, did you know who this person was at the time?
At the time, I did not.
Do you know now?
It was Roy.
Ms. Franklin, one more question while you're standing. From the time you walked out in the balcony and first saw Ms. Patterson to the time you heard that gunshot, how long was that?
It all happened so fast. I mean, it couldn't have been more than just a couple of seconds.
Thank you, Ms. Franklin. You could take your seat. Ms. Franklin, after you heard that gunshot, what did you do?
Well, when I heard the gunshot, I didn't know where the gunshot came from. I didn't know who shot it. And so I screamed and I ran inside my condo and I turned out all my lights and I locked my door and then I hid.
Did you talk to Ms. Patterson at all for the rest of the night?
Peyton did call me.
How is Ms. Patterson acting on this phone call?
She was so distraught. I mean, she was practically hysterical.
Objection, Your Honor, it's speculation. The witness is speculating to the mindset of Peyton Patterson, that she was distraught.
Your Honor, if I may, this is a rationally based perception based on what she heard, what she was saying. If the witness be allowed to testify further, you will hear that she was, if I may, is this outside the hearing of the jury?
This will be outside the hearing of the jury.
If the witness is allowed to testify further, you will hear her say, or we anticipate she will say things like she was crying, she was stuttering, she was clearly distressed about an event, and that is all the witness is saying.
I'm going to sustain the objection, and we are now back on the record, but you may re-ask your questions and ask about any specifics that you want to and that she can testify to.
And
Yes, Your
before
Honor.
opposing counsel continues, I ask that this witness's testimony be stricken from the record about Peyton being distraught.
Yes, the last question and answer will be stricken from the record.
Yes,
Thank
Your
you.
Honor.
And I'll ask the jury to ignore that.
All right, Ms. Franklin, just without describing Ms. Patterson's mindset on that phone call, could you tell us how she sounded on that phone call?
She was talking very fast and she stuttered a couple of times.
Objection, Your Honor. This is outside the scope of the mock trial universe. Nowhere in the materials, nowhere in her affidavit does she state that Peyton Patterson is stuttering or anything of that sort.
Counsel?
Your Honor, if I may, it is a rationally based perception based on, if you excuse me for a minute as I find the exact quote. Your Honor, if I may, on the third page of the witness's affidavit, page 29 of the mock trial, the witness testifies that Peyton was so distraught, but everything he said was consistent with what I saw. Your Honor, it's a rationally based perception. If the witness deemed her to be distraught, that she can therefore testify as to exactly what the witness was doing on that phone call in that manner.
May I respond, Your Honor?
Yes.
You've already ruled that it was speculation for her to testify to the mindset that she was distraught. Furthermore, Your Honor, foundation has not been laid that the defendant was stuttering or stumbling over her words or talking fast. And it's outside the scope. It materially alters the facts in this case. Therefore, it should not be admissible in court today.
Counsel, I don't think you can have this both ways. I don't think you can object to her stating her perceptions and thereafter she's asked to state specific things and then object to her stating of specific things. So I'm going to overrule the objection. Counsel, I'll ask you to ask her as specifically as you can about her general senses, not what she speculated, but what she specifically observed?
Yes, Your Honor.
Thank you both.
Ms. Franklin, what specific things did you observe about the defendant on that phone call?
Well, when I was on the phone with Peyton, she was talking very fast and it appeared that she was crying.
Now, Ms. Franklin, what did she tell you on that? Or first, before I ask that, how soon after you ran inside did she call you?
It was right after I turned out all my lights and locked my door, so probably not more than 1 or 2 minutes.
And what did she tell you on that phone call?
She told me about what happened.
Your Honor, this question calls for hearsay.
Your Honor, if I may, falls under excited utterance. We have already laid the foundation, as well as there hasn't been a statement offered yet, but the anticipated statement does fall under excited utterance, as we have just, the witness has just testified that she was under the stress of the startling event. It happened only a few moments after she witnessed the gunshot in which Peyton Patterson was present in the parking lot, as well as based on her testimony as to the how the witness was speaking and how Ms. Patterson was speaking on that phone call, that she was still under the stress as well.
Counsel?
Yes, Your Honor. This does not fall under excited utterance because the opposing counsel just testified that she has to be under the stress or the duress in order for it to count. And Your Honor, simply too much time had passed for the defendant to gather herself. She had to locate her phone, fumble for it. After she found it, she had to unlock it, pick it up, look for Frances Franklin's phone number in her phone, click it, wait for it to ring, and then after it rung, before she began to say what happened.
Objection is overruled, and you may proceed, but counsel, you certainly may cross-examine on those things.
Ms. Franklin, what did Ms. Patterson tell you on that phone call?
Peyton told me about what happened in the parking lot, and she told me about how she was at the trunk of Rory's car and she was getting all this stuff out, and then her gun got stuck on something, and when she was trying to pull it loose, it accidentally went off, and it shot Rory, and about how Rory died.
This is my final question. I want you to look at the jury when you answer this question. Ms. Franklin, was what you saw in the parking lot that night and what you just demonstrated here in court today consistent with what Ms. Patterson told you on the phone call that night?
Yes.
No further questions, Your Honor.
Thank you. Counsel?
Yes, Your Honor. Now, Ms. Franklin, you've known Peyton for a long time, haven't you?
I have.
In fact, you claim to know Peyton better than just about anybody in Crater County, correct?
Yes, I mean, I've known Peyton basically my whole life, and we hang out a lot, and so I know her very well.
Yes, back in high school, you'd always try to sit next to her in lunch.
Yes, we were friends in high school.
You somehow always wound up in the same place, correct?
Yes, we were friends, and so we had similar friends with similar friend groups and always ended up hanging out together.
Ms. Franklin, now you coincidentally live in the same apartment complex, correct?
She did move in, yes.
Now, you work at a prison, don't you?
I do.
Objection on relevance.
May I respond?
Counsel?
We're simply laying foundation for a question that I'm about to ask, Your Honor. By establishing the fact that she works at a prison, we're showing that having known the conditions, being around criminals all the time, she knows what the conditions are like, and she wouldn't want her close friend Peyton to end up there. Therefore, it goes toward bias.
Counsel?
Your Honor, her working at a correctional facility in no ways goes to her bias in today's case. Your Honor, her experiences there's no foundation, there's nowhere in the case material what her experiences were at the correctional facility or even what kind of correctional facility it was.
Objection sustained. I don't find that this particular evidence is relevant to the issue before the court and the jury on the guilt or lack of guilt of the defendant.
Yes, Your Honor.
Yes, Your Honor.
Now, Ms. Franklin, I want to talk about Rory and Peyton's relationship. After spending time with both of these girls, you noticed that their relationship grew tumultuous, correct?
At times it could tend to be that way, yes.
And you'd hung out with Rory a few times, correct?
I did.
And while you had hung out with Rory, you noticed that she'd constantly be on her phone messaging, sending photos of herself to Guy Rosling, correct?
She did contact him a lot while we were together, yes.
Thank you, Ms. Franklin. Now, I want to circle back to Rory and Peyton's relationship. You observed and you noticed that they would fight a lot, correct?
Like I said, at times their relationship could get a little heated, and they did have little arguments from time to time, just like any close friends
Thank you,
do.
Ms. Franklin. And after they had an argument, sometimes Peyton would come down to your condo to cool off, wouldn't she?
Yes, she loved coming to hang out with me, and so she would often come over.
When she came to hang out with you, she'd complain to you about Rory, correct?
No, she did not. She never talked bad about Rory.
Oh, so it's not your testimony today that the defendant didn't complain? The defendant didn't complain to you while she hung out with you?
Yes, we often talked about other things. I mean, she never really wanted to focus on the negatives in life, and so we would often play video games or listen to music.
So, did Peyton, when she came to hang out with you, complain to you? Yes or no?
She did not badmouth Rory, no.
Do you remember preparing a sworn affidavit for the court today in which you swore to tell the whole truth and nothing but?
Yes.
Permission to approach the witness?
Yes.
Let the record reflect I'm showing a copy to opposing counsel. Ms. Franklin, please read silently as I read aloud. After a few complaints and possible solutions thrown out here and there, Peyton would walk home, leaving the both of us feeling much better about life. Did I read that correctly?
You did, and in my statement and here today in court, when I said those things, I was referring to life in general. I mean, everything about life, our jobs, our social lives, everything, not just Rory.
But including Rory, yes?
I mean, sure, but we didn't focus on Rory.
Thank you, Ms. Franklin. So, and after you hung out with her, she would return back to her apartment, correct?
Yes.
So let's talk about how she came to hang out with you on the night of the incident. You testified earlier that the defendant smoked a spliff, correct?
She did smoke one, yes.
And after she smoked the spliff, she returned back to her apartment, correct?
Yes.
And that's when the incident occurred, yes?
I mean, there were several hours between the two, but that is how things went along.
Yes. Now, Ms. Franklin, later in that night, you claimed that you saw everything that happened, correct?
I did.
But the streetlights were out, right?
Yes, one of the streetlights was out.
And you went outside at 9:30 p.m., didn't you?
Yes.
So just to clarify for the jury, at 9:30, when the streetlights were out and it was dark outside, you were able to see everything?
Yes, because we were in the parking lot of our condo complex, and there are a ton of windows and glass doors, and so there was lots of light in the parking lot.
Thank you, Ms. Franklin. Now, later that night, you testified that the defendant called you, correct?
She did.
But you don't know if she called 911 before she called you, do you?
I do not know. All I know is that she called me.
But you don't know if she called 911 at all, right?
No.
No further questions at this time, Your Honor.
Thank you. Counsel?
Yes, Your Honor, very brief. Ms. Franklin, opposing counsel just asked you 23 different questions. How many did they ask you before today's trial?
None.
How many did law enforcement ask you before today's trial?
0.
No further questions, Your Honor.
Thank you. You are excused. You may step down. Call your next witness, please.
Yes, Your Honor. This is called Chandler King.
Thank you. Mr. King, I ask you to affirm that you understand you've already been sworn in and you will testify under oath.
Yes, Your Honor.
Tell us your name.
My name is Chandler King.
And Mr. King, what do you do for a living?
I'm a forensic ballistics investigator for the Tennessee Bureau of Investigation.
What do you do as a forensic ballistics investigator?
Well, it is my job to investigate any incidents that occur specifically with firearms.
You have any formal education?
Yes, I have a bachelor's in chemistry and a master's in physics from Middle Tennessee State University.
What did you do before becoming an investigator?
I spent 8 years in law enforcement, first as a sheriff's deputy and then as a crime scene investigator, and since then I've spent 5 years in my current job.
Have you received any certifications in the area of firearms?
Yes, I am certified by the Association of Firearm and Toolmark Examiners, and I am also certified by the National Rifle Association to teach firearm classes.
Your Honor, we tender Mr. King as an expert in ballistics and forensic firearm examination.
All right. Counsel, any objection?
Yes, Your Honor. In Mr. King's sworn affidavit, he states that he works for the Tennessee Crime Lab
Does
as
this
an...
need to be a jury out hearing?
No, Your Honor.
Okay, you may proceed.
He works in his daily job as a quoted ballistics expert in his sworn affidavit. Therefore, I ask that Mr. Watley confine his, tender him as an expert in just ballistics, not ballistics and forensics, as I believe, since in his sworn affidavit, it states that he is a ballistics expert and only a ballistics expert, that he only be qualified in this field.
All right. Counsel?
The term I used was forensic firearm examination, which is well within that field. However, the field of ballistics is a very overarching field of expertise, and I'll be glad to tender him as an expert in that field.
All right. Then it appears the request has been accepted, and so we will continue, and he may testify in that field and whatever it encompasses.
Yes, Your Honor, as long as ballistics only refers to testimony and conclusions regarding the firearms themselves, nothing beyond.
Well, I'll ask that you judge that as you hear the questions asking.
Yes, Your Honor.
And you may object again if you find one objectionable.
Yes, thank you.
Thank you. You may continue.
Mr. King, how did you become involved in this case?
I performed the investigation into the bullet, shell casing, and firearm recovered from the incident on June 18, 2018.
All right, before we get into your specific conclusions in this case, walk the jury through what you typically try to focus on in cases like these.
Cases like these, I'm trying to determine if the bullet and the shell casing were once the same round, and if that round was fired from the recovered firearm or from somewhere else.
And how do you go about doing that?
Well, I perform a microscopic matching analysis on the bullet and shell casing, as well as comparing them to test fires from the firearm. Then I also perform a physical examination of the firearm.
Is this a methodology that you applied to your work in this case?
Absolutely.
Did you apply that methodology reliably?
I did.
And is that methodology considered reliable by other experts in your field?
Yes, it is.
Did you have sufficient facts and data to reach a conclusion both to the matching analysis that you mentioned and to any other conclusions regarding the firearm itself?
Yes.
And did you reach those conclusions to a reasonable degree of scientific certainty?
I absolutely did.
What is your conclusion regarding the matching analysis?
I concluded that the bullet and shell casing were a match to one another, meaning they were once the same round, and that they were a match to the firearm, meaning that they had been fired from the recovered firearm.
And what, if any, other conclusion did you reach regarding the firearm itself?
The firearm itself, I concluded that the trigger pull, in other words, the amount of force it takes to pull the trigger of the pistol, had been dangerously lowered.
All right, we're going to start with your first conclusion regarding the matching analysis. You mentioned a bullet and a shell casing. How did these two things function together?
So the bullet is the copper-pointed tip of a round. This is the part that actually projects out of the gun into the target. Now on the back of this you have the cylindrical shell casing, usually made of brass. This houses the propellant. In the case of this firearm it was cordite. And on the back of that you have the firing cap. Now when the gun is discharged, when the trigger is pulled, what happens is the firing pin strikes the firing cap, which ignites the cordite inside the shell casing, which thrusts the bullet out of the gun and ejects the shell casing.
How do you apply a matching analysis to a bullet that's already been fired?
Well, after it's been recovered from wherever it is, I look at it under a microscope to look at the striation marks left by the rifling grooves inside the barrel of the gun.
And how were you able to determine something matching from that type of analysis?
What I did is I compared those striation marks from the gun to the striation marks on the shell casing. And if they matched, it means they came from the same firearm, because every firearm leaves a unique set of striations. I then performed a series of test fires into a standard controlled water tank and took the bullet and shell casing that I definitively knew had been fired from the gun and compared those striation marks to the striation marks on the bullet and shell casing recovered. I found them to be perfectly identical.
What type of firearm are we talking about in this case?
Is a Glock 19 Generation 3 9mm handgun.
And what type of bullet?
It's a Barnes 115 grain, which is a standard self-defense ammunition.
So how did your matching analysis of the bullet recovered from the brain and the defendant's gun, what did you reach from this analysis?
Through my analysis, I concluded definitively that that bullet had been fired from the recovered firearm.
All right, going on to your second conclusion regarding the firearm itself. You mentioned trigger pull. How was this trigger pull modified?
So I found that it had been lowered to approximately 3.75 pounds, which is below the minimum safety limit of 4 pounds and made it extremely prone to accidental discharge.
Just about how safe is a firearm with a trigger pull of 3.75?
It's not safe at all.
Why is it not safe?
Well, you see, as you approach the minimum safety limit of 4 pounds, as that trigger pull is lowered further and further, the gun gets more and more dangerous because as it goes lower and lower, it takes less force to make that trigger pulled. And so when it's below 4 pounds, literally just the normal handling of the gun, let alone some of the stressful events that I've heard talked about today, could easily have caused that gun to go off.
Objection, Your Honor. In the witness's sworn affidavit, he states that when analyzing the gun, that it simply increases the likelihood of an accidental discharge. He has no knowledge of specific events according to the mock trial universe that could have caused. We have no objection to Mr. King testifying in his expert opinion that this was a dangerous modification or that it increased the likelihood of accidental discharge, but to delve into unlikely scenarios is clearly outside the scope of his expertise and outside the scope of the mock trial universe.
Response?
Yes.
Your Honor, what we know is that the trigger pull was modified. We know what it was lowered to, and we know what this meant for the gun. Mr. King is just trying to apply this to scenarios, and he's just saying that the type of scenarios that would make this gun go off is consistent with the evidence that we've seen today.
Thank you both very much. Your objection is sustained in part, and I will direct the jury not to consider the part of the statement he just made that has reference to things he has heard about or learned about other than through direct observation, but he can continue to state his expert opinions about the gun itself.
Yes, Your Honor, and I ask that before Mr. Watley continues that testimony be stricken from the record.
Yes, it will be.
Thank you, Your Honor.
All right, we want to talk about that trigger pull for just a moment. For those of us who might not know, 0.25 pounds may not seem like a lot. Why is it so significant for a trigger pull to be lowered this much?
Well, it's 1/4 pound below the minimum safety limit, which is already dangerous. And so now you've gone from a trigger pull that's getting more and more dangerous, and once it's below 4 pounds, it becomes so prone to accidental discharge that extra 1/4 pound could literally be the difference between life and death.
Thank you. Nothing further.
Counsel?
Yes, Your Honor. Now, Mr. King, I want to start off by talking about your educational background.
Yes.
You state in your curriculum vitae that you submitted to the court today that you have a master's degree in forensic science, correct?
I believe that's in my curriculum vitae. However, I don't know how up to date it is.
So it's not up to date because in your sworn affidavit, you state that this master's degree is in physics, correct?
That's correct, and this is why there was no attempt to put it in evidence or anything because it's inconsistent.
So this inconsistency, that's a yes to my answer, that this degree is not listed in your curriculum vitae that was submitted to the court.
The curriculum vitae, we found out it was wrong, and that's why we haven't brought it up. What I said in my affidavit is absolutely true. My degree is in physics. I just want to make that clear.
Okay, Dr. King, let's move on to this modification of the gun that you've been talking about just a few moments ago. You concluded that the trigger pull on the gun was 3.75 pounds instead of 4, correct?
That's correct.
So you're here to tell the jury that this gun was only 7% easier to shoot. Isn't that right?
7% easier to shoot than the absolute minimum of what's considered the threshold of safety. Obviously, a normal gun, such as the gun I heard mentioned from Investigator Benson, obviously would be much higher than 4 pounds because the industry standard is to not even come close to that.
Now, Dr. King, I want to get this straight for the jury. You have no idea who modified this gun, do you?
No idea. This could have. There's no way through my investigation to know who, when, or why this modification took place.
So you have no idea, and it's a possibility that it was the defendant herself, isn't it?
In theory, however, what I know of this type of modification, it's an extremely involved process. There are very few people with the expertise and knowledge capable of making a mechanical modification of this type. It requires a lot of heavy machinery and such.
Yes, Dr. King, we'll get into Miss Patterson's qualifications later. Now, let's turn to the gun you analyzed physically. You determined that this gun, recovered from the crime scene, matched the bullets from the victim's brain and the shell casing, correct?
Absolutely. The recovered bullet was fired from that gun. There's no doubt about it.
And Dr. King, since these were all found from the crime scene, these were all from a gun that's standardly issued to park rangers, correct?
Yes, the Glock 19 is the standard issue. However, the trigger pull is incredibly not standard.
So let's talk about that trigger pull. Whether it had 3.75 pounds needed to pull the trigger or 4, there still had to be weight on the trigger for that gun to shoot, correct?
That's absolutely true. Force has to be applied for the trigger to go off. The lowering simply increases the likelihood that a force other than someone's finger causes it to go off.
A force other than someone's finger.
That's
Is
correct.
that what you just stated?
A lesser force than someone's finger.
Did you think that was important information in your conclusions?
Yes, I just said it, so it's important.
Then why didn't you include it in your sworn affidavit?
I did. I talk about the fact that the minimum standard is 4 pounds, and it had been lowered. This increases the likelihood of accidental discharge. Someone's finger intentionally pulling the trigger is not accidental. Something other than someone's finger is accident.
But that's a yes to my question that you mentioned nothing about a finger in your sworn affidavit, correct?
I just described to you how it's in there. The accidental discharge would be a non-finger, and a non-accidental discharge would be a finger.
Thank you, Your Honor. No further questions at this time.
Thank you. Is there any redirect?
Yes, Your Honor, brief. All right, we just heard the state prosecutor ask you about 30 questions or so. And just before we go any further, you're not a doctor, are you?
No, I do not.
You're not Dr. King. Who do you work for?
I work for the state of Tennessee.
And how many questions did the state, who you work for, ask you before today's trial?
They asked me no questions.
Thank you.
Objection, Your Honor. Recross must be constricted to things that were within the direct. And nowhere did I ask in my direct examination of what kind of questions he was asked before today's trial. Therefore, it is outside the scope of my examination.
Counsel?
To a cross, not a direct. What was asked in the cross
Excuse
were
me.
30 questions. We're just highlighting the fact that none of those questions were asked before today's trial. That's extremely within the realm of the cross because it's the cross itself.
Objection is overruled. I believe that counsel's statement is correct and that you can raise to notice something that didn't happen in a cross as well as what did happen in a cross.
Yes, Your Honor.
Anything else?
No, Your Honor.
Anything else? Thank you. You may step down. Defense have more evidence to present.
Yes, Your Honor. At this point, the defense calls Peyton Patterson to the stand.
Ms. Patterson, do you also understand that you have been sworn and that you will be testifying under oath? Yes, Your Honor.
Please tell us your name.
My name is Peyton Patterson.
Ms. Patterson, have you been sitting in this courtroom throughout today's trial?
Yes, I have.
Have you been listening as these prosecutors have been trying to convince the jury that you murdered Rory Reynolds?
Yes, I've been listening.
Ms. Patterson, will you look this jury in the eyes and tell them once and for all, did you murder Rory Reynolds?
Of course I didn't murder Rory. She was my best friend in the whole world, and I would never do anything to hurt her, I swear. It was all a horrible accident.
Did you take any action whatsoever that you thought might harm Rory Reynolds or lead to her death?
No, of course not.
Did you point a gun at Rory Reynolds' head and pull the trigger?
No, God, no.
Before we talk about what actually happened that night, I'd like to let the jury get to know you some. How old are you?
I'm 23 years old.
And where do you live?
I live in Crater County, Tennessee.
Where did you grow up?
Believe it or not, I grew up in Roughneck, Tennessee.
And did you have any experience handling firearms while growing up?
Yes, my mum was an ex-Marine and my dad was an avid hunter, so I learned how to handle firearms pretty early on.
And what did they teach you about handling firearms?
They taught me all the rules one should know.
And did you ever graduate high school?
Yes, I graduated in 2013.
Did you attend college after that?
Yes, I started Crater State that fall.
And what did you study at Crater State?
I studied forestry and wildlife sciences because I've always loved being outdoors.
And did you get any kind of job after graduating college?
Yes, I became a park ranger at Crater State Park, and frankly, it's the best job in the world because I got to be outside all day, and I got to take care and preserve the park so that families...
Objection, Your Honor, relevance.
Your Honor, if I may, I'm just merely letting the jury understand who Miss Patterson is. Furthermore, her experience as a park ranger goes to her experience with firearms.
Objection overruled. I will give you some leeway in simply creating context, but please move on then to your next questions.
Yes, Your Honor. I'm sorry, Miss Patterson. What were you saying?
I was just saying that I loved being a park ranger because I got to be outdoors all day, and I got to be a part of a place that allowed families to come and enjoy nature.
And did your job as a park ranger require you to carry any kind of firearm?
Yes, all the rangers were issued service pistols.
Was there any kind of certification or test that you had to go through to obtain this pistol?
Yes, all the rangers were issued, they all had to take the fitness and field arms certification test.
And did you pass this test?
I did.
How did you know Rory Reynolds?
Rory Reynolds was my best friend in the whole world.
How did you meet her?
I met her at freshman orientation at Crater State, and she and I just really hit it off, and we became best friends, and we roomed together all through college, and we even decided to live together afterwards, and she was such a joy to be around. She lit up every room she went in, and her smile was so sweet, and she had such a great way of making me laugh, and I miss her so much.
How would you describe your relationship with Miss Reynolds?
We were like sisters. I was an only child growing up, so I never got the experience of a sister, but once I met Rory, I knew what that was like, and we knew how to pick at each other sometimes, and over the years we could get on each other's nerves, but we were the best of friends.
Did you also meet someone named Guy Rosling while you were in college?
I did. He and I dated for about a year. We started dating my sophomore year.
And how did that relationship end?
After a year, he got some acting gig on the West Coast, so he moved away and we broke up.
At any point, was there any kind of jealousy between you and Rory Reynolds about Guy and Rosling?
No, of course not.
Now, on the night of June 18th, 2018, were you home?
Yes, I was.
And what were you doing at home?
Rory and I were talking on the balcony about our days, drinking a couple beers like we normally did.
Now, it's been alleged that there was some kind of argument that night. Is this true?
Yes, it's true.
And how did this argument begin?
Well, I went inside to get another drink, and that's when I noticed a postcard that was about to fall out of Rory's bag, and so I looked at it, and that's when I realized that Rory thought that she couldn't be truthful with me, and that broke my heart.
And is this when that argument began?
Yes, it is. See, by looking at the postcard, it became evident to me. See, about a year earlier, my friends and I had planned a spring break trip to Miami, and we had booked a bunch of things like Airbnbs, and we were really excited about it. But last minute, Rory backed out, and she didn't have any friends or relatives in the West Coast, so the only person she knew was Guy Rosling. So my friends and I asked her, is that who you're going to go visit? But she always denied that. And seeing this postcard, it said it was from California to Rory, and it said 1 year ago we were together here. It just made me think that she felt she couldn't be honest with me, and even though we were like sisters.
Today, the government has been trying to insinuate that the argument that you had was violent and physical. Is this true?
No, of course not. I'm proud to say I have never, ever been in a physical fight with anybody, and I would never, ever hurt
anyone in a physical fight or any other kind of fight, and I did not hurt Rory.
And how did the argument end?
After about an hour, Rory said, I've had enough, I'm going for a drive.
And how did you react when she said this?
This made me upset.
Were you upset about the postcard that you had seen an hour earlier?
No.
Why were you upset, Miss Patterson?
I was upset because Rory did this thing when she would get worked up where she would go for a drive, and sometimes she would be gone for an hour, other times days on end, and if she was upset with me in some way, she would never text me and let me know where she was or if she was okay, and I knew that she had had drinks that night, many drinks to my knowledge, and so I thought she was overreacting, and I just didn't like it when she would do this.
So what did you do when she said this?
I went to go get my things from the car.
Why did you have things in Rory Reynolds' car?
Well, my car was in the shop, so she and I had been carpooling.
What things did you need to get out of Rory Reynolds' car?
I had to get my gym bag and my phone charger and my service pistol.
Now these next few seconds are extremely important, so I'd like you to look this jury in the eyes and explain it to them as best as you can, Miss Patterson. What happened as you were getting your things out of Rory Reynolds' car?
Well, I started to get the gym bag and the charger out of the car, and I was so preoccupied. I started to pick up my service pistol, and it was stuck on something. It was caught, and I pulled at it to try to get it to come loose from whatever it was caught on, and I pulled again to try to get it to come off, and I just wasn't thinking it. I pulled harder, and I tripped back, and the gun went off. The gun fired.
Did you think that anyone was outside in the parking lot with you at this point, Miss Patterson?
No, I thought I was the only one outside.
What happened when the gun went off?
At first I thought everything was okay. I didn't know anyone was outside. But I looked over and there was a body on the ground, and I went closer and I realized that it was Rory, and there was blood all over her sweet face, and I tried to stop the blood because it was just coming out of her head, and I held a towel up to her head to stop it, but it got through. The blood wouldn't stop.
At any point, Miss Patterson, did law enforcement arrive on the scene?
Yes, they arrived very quickly.
And did they ask you any questions?
Yes, they took me to the police station.
Miss Patterson, what did you tell law enforcement when they asked you these questions?
I told them it was an accident. I didn't mean to hurt her, I swear.
No further questions, Your Honor.
Counsel?
Yes, Your Honor. Miss Patterson, from a young age, your parents taught you how to handle firearms, yes?
Yes, they did.
Your mom was a Marine?
She was.
And you were in the ROTC?
I'm proud to say I was.
So it's safe to say that you know how to handle firearms with skill, correct?
That is correct.
You are now a park ranger?
I was a park ranger.
You carried a gun as a part of your job being a park ranger, yes?
Yes, all the rangers did.
You passed your park ranger field arms certification test with flying colors. Isn't that right?
Yes, I try to excel at everything that I do.
So you excelled at this test, yes?
I did well, yes.
So you know that a gun should be stored safely, yes?
Yes, I knew that.
And you know that it is unsafe to put your finger anywhere near the trigger of a gun unless you are ready to fire, correct?
Yes, I know that, and I wish I had been thinking about that on June 18th, but I wasn't, and I will forever regret that I wasn't more aware.
So that's a yes to my question, Ms. Patterson. It is unsafe to put your finger on the trigger of a gun unless you are ready to fire. Yes?
Yes, it is unsafe, but that is why we're here today.
Now, Ms. Patterson, I want to talk about your relationship with the victim, Rory Reynolds. You met Rory your freshman year at CSU, yes?
Yes, I did.
But you and Rory began fighting during your senior year, correct?
We bickered a lot more, yes. We knew how to get on each other's nerves, but I will say we were also still very close friends.
And this fighting got even worse after you moved in together, didn't it?
Our arguments did become more frequent, especially as Rory began to drink more.
And Rory would make fun of you, wouldn't she?
Rory did sometimes poke fun because she was a very funny person sometimes, but sometimes she'd take it a little bit too far. We both kind of did that to each other.
When she took it too far, Miss Patterson, she would call you names, yes?
Sometimes, but it's kind of as sisters do.
But you were tired of it, weren't you?
Of course it got tiring in that moment, but we were still friends. Otherwise we wouldn't have lived together after college.
That's a yes to my question, Miss Patterson. You were tired of it, weren't you?
When she would say things that I didn't find very funny in that moment, I didn't necessarily laugh, but I wasn't tired of her, if that's what you're saying.
It's not what I'm saying, Miss Patterson. What I'm saying is you were tired of her making fun of you, yes?
Sometimes I would get tired of it, but I was not continually upset with that, no.
That wasn't my question, Miss Patterson. My question was, you were tired of her making fun of you, yes?
No one likes being made fun of, but it wasn't even very mean. But sure, I didn't like when we would, bickerings would become more unfriendly, I guess.
So that's a yes to my question, Miss Patterson.
Sure.
Now I want to move on to what else you were upset with the victim about. You met a man named Guyan Rosling in college, yes?
Yes, I did.
You dated this Guyan for over a year?
About a year.
You claimed on direct that you and Rory never had jealousy about this, correct?
Not really.
But you said in your own words that once or twice you suspected Rory was jealous of your relationship, yes?
I did think that sometimes while we were in college.
And Rory even told you that she thought Guyan was too hot for one person to handle, yes?
That was one of Rory's funny comments that she did make, yes.
Now, you and Guyan broke up when he moved to the West Coast, correct?
That's just right.
But after you broke up, you had a suspicion that your best friend was sneaking off to LA to meet up with your ex-boyfriend, correct?
I did think that was, that she was going to LA to see him because to all my friends and I's knowledge, she didn't have any friends or relatives in LA, so that seemed to be the only person she would go and visit. And all my friends were kind of startled that she didn't go to our senior trip together because of that.
And now you confronted Miss Reynolds about sneaking off to LA to meet up with your ex-boyfriend, didn't you?
It wasn't the fact that he was my ex-boyfriend, it was the fact that she was leaving our trip that bothered me. But yes, we got in an argument about it, I'm sorry to say.
Maybe it wasn't clear, Miss Patterson. My question wasn't what bothered you. It was that you confronted Rory about going to LA instead of going to Miami with you, yes?
Yes, I did, because she was ditching our trip.
And when you confronted Miss Reynolds about this, she got defensive, yes?
Yes, she did, and we got in an argument.
She started yelling at you, didn't she?
We started arguing. It was a big fight, I'm ashamed to say.
You argued about this very same thing on the night of June 18th, the night that Rory was shot and killed, yes?
Yes, it did come up, yes, definitely.
Now I want to talk about that night. You were with Rory on the night of June 18th, 2018, yes?
Yes, I was.
And that night you found a postcard in Rory Reynolds' bag, correct?
It was about to fall out of Rory's bag, yes.
Would you recognize that postcard if I showed it to you today?
Yes, I would.
May I approach the witness?
Yes.
Let the record reflect I'm showing a copy to opposing counsel.
Thank you.
Here you go, Ms. Patterson. Now, this is the postcard that you found in Rory Reynolds' bag, correct?
That I found about to fall out of her bag, yes.
And is this a fair and accurate copy of that postcard?
Yes, it is.
Your Honor, at this time, we would like to enter in Exhibit B into evidence the postcard found in the apartment. Its authenticity has been stipulated.
Your Honor, now that the foundation has been laid, I have no objection.
Thank you. The postcard is admitted and may be considered by the jury.
Now, Miss Patterson, this postcard is from LA, yes?
Yes, it is.
This postcard from LA reads, 1 year ago we were together here, yes?
Yes, exactly.
And about a year before is when you suspected that your best friend had snuck off to LA to meet up with your ex-boyfriend, isn't it?
Yes, but the thing about it is that this confirmed that she was seeing someone, or she had some sort of relationship in California, when she had told my friends and I that there was no relationship, and that wasn't why she was leaving the trip.
But in your sworn affidavit, you never stated that that's the reason she left. You never stated in your affidavit that she did not know anyone in LA, and that she told you that she didn't know anyone in LA, did you?
No, to our knowledge, we didn't know of any friends or relatives that she had there, to my friends and I's understanding.
And the only person you knew who lived there was Guyan Rosling, yes?
Yes, exactly.
So like I said earlier, Miss Patterson, when you saw this postcard, LA is where you suspected that Rory had gone off a year before to meet up with Guyan, yes?
Yes.
And then you took this postcard and you marched out to the balcony and you confronted Rory Reynolds about it, yes?
Yes, I wish I hadn't even brought it up. It was so silly.
And then you got into a huge fight, didn't you?
We did get into an argument, yes.
That fight was so loud that you think people all the way down the street heard you, correct?
I'm ashamed to say yes, and I don't think Rory's drinking helped that at all.
After about an hour of fighting, Rory said she'd had enough and was leaving, correct?
Yes, she did.
But before Rory could leave, you went down to her car first, yes?
Yes, I had to get my things out of the car for work.
And your gun was in that car, wasn't it?
Yes, I had to get it out of the car because if she had been drinking a lot and was going to drive, I especially did not want her to get pulled over and that be found in the trunk. I don't think she's a licensed handgun carrier.
But that's a yes to my question. Your gun was in that car.
Yes, I had to get it out.
And when you went down to that car, you were so angry that you couldn't see straight, correct?
Yeah, that is a figure of speech, but yes, I was very upset in that moment.
And in the midst of this anger, you grabbed your gun, yes?
Yes, I had to pick it up to get it out of the car.
So that's a yes to my question. In the midst of this anger, you grabbed your gun.
Yes, and that's why I was not more aware, and that's why I wasn't thinking, because I was preoccupied.
But in the midst of this anger, you must have just accidentally put your finger on that trigger.
I don't know how it went off. My finger might have touched it, or something I was holding might have brushed against it. I honestly don't know. I just know that it went off, and now Rory's dead.
But Miss Patterson, in your own words, you must have just accidentally put your finger on that trigger, yes?
And if you look further in my statement, it will say that either my finger touched it or something else. I really don't know. I can't tell you.
But that's a yes to my question. In your sworn affidavit, it says I must have just accidentally put my finger on the trigger, correct?
Or something touched it is what I think it says next.
And after you must have just accidentally put your finger on the trigger, that gun just accidentally fired and that bullet charged straight into Rory Reynolds' head, yes?
Yes, and I wish to God that it had gone anywhere else, but it didn't.
That's right, Miss Patterson, it didn't. It went straight through Rory Reynolds' brain, correct?
Yes, it did.
Miss Patterson, after all of this coincidentally happened, you didn't even call 911, did you?
I couldn't find my phone, and I was just trying to help Rory. I thought she might be saved.
That's a yes to my question, Miss Patterson. You
couldn't
didn't even
find my
call.
phone.
So yes, you didn't call 911.
No, I didn't. They arrived very quickly, though.
Thank you, Your Honor. No further questions.
Thank you. Is there redirect?
Briefly, Your Honor. How much time do I have left, first of all? Thank you. Ms. Patterson, the government has been trying to make it seem like there was some kind of constant tension between you and Rory Reynolds. Is this true?
No, we would sometimes bicker, but we were best friends in the whole world.
And in the moment that the gun went off, were you angry at Rory Reynolds herself?
No, of course I wasn't angry at Rory. I was just angry that she was going to go drive, and I thought it was dangerous, and I didn't want her to get hurt because I loved her.
No further questions, Your Honor.
You may step down. Does the defense have further evidence to present?
Defense rests, Your Honor.
Thank you. Then unless there's anything else, I believe we are ready for closing arguments. Counsel, are you ready to proceed?
Yes, Your Honor.
You may.
And before I begin, I would like to reserve any remaining time that I have for rebuttal, up to a minute.
All right.
Thank you, Your Honor. Your Honor, members of the jury, I want you to think about how many coincidences it takes before something is no longer a coincidence. This is a simple case. You only have one thing to decide. Did the defendant shoot and kill Rory Reynolds on purpose? Or did the defendant shoot and kill Rory Reynolds on accident through a series of wildly unlikely coincidences? Rory Reynolds, the victim, was a vibrant young woman who had only just begun her life. She loved great music, had a guilty pleasure for fast food, and was beloved in her community. She was an incredible friend, the kind you could tell your secrets to. But she had one flaw. She fell for forbidden love. And that flaw cost her her life. Rory fell for Guyan, the defendant's ex-boyfriend. And she hid that secret from the defendant for over a year, until on the night of June 18th, a postcard revealing that secret meetup was discovered by Peyton after an evening of drinking and smoking. So, with her inhibitions down, the defendant's jealousy erupted into rage. She saw red. She first beat Rory Reynolds in a fight so violent that neighbors overheard it and furniture was overturned. She then took that postcard from the apartment to the scene of the crime, where she grabbed her gun, put her finger on the trigger, and shot Rory Reynolds straight through the brain. You see, Peyton Patterson knows her way around a gun. She spent her entire life being trained in gun safety and learning how to hit her intended target. Mr. King came up here and said only a qualified gun expert would be able to modify her gun. And Peyton Patterson is a qualified gun expert. But the defense wants you to believe that despite all of this training, the defendant just accidentally put her finger on the trigger, just accidentally fired her weapon, and just accidentally hit her victim straight through the brain. I understand that you would like to look at the defendant and think, maybe it could be a series of wildly unlikely coincidences. But could this mountain of evidence all just be a coincidence? Is it a coincidence that the postcard, the thing that confirmed Rory had betrayed her, was found at the scene of the crime? Is it a coincidence that Rory Reynolds' body had severe contusions and lacerations, cuts and bruises consistent with a fight before she was shot and killed? Is it a coincidence that a park ranger trained in gun safety just accidentally put her finger on the trigger? Is it a coincidence that this same person trained in gun safety just accidentally aimed her gun directly into Rory Reynolds' brain? Finally, is it a coincidence that the defendant couldn't find her phone to call 911, but could find her phone to call her friend Francis Franklin? Members of the jury, coincidence after coincidence after coincidence after coincidence and after coincidence. It is no longer a coincidence. It is no accident. It's knowing. It's second-degree murder. Find the defendant guilty. Thank you.
Counsel?
Yes, Your Honor. Imagine you're buying a car. You find one that you really like, and you're pretty much sold on it. So you say, Mr. Salesman, I like this one. Mind if I take it for a test drive? But then he says, oh no, let's just skip that part. Here, sign the paperwork. Would that actually happen? Would you honestly expect the salesperson to tell you that you couldn't test drive that car before buying it? Of course not. And that's because even though in that test drive, it only may take you a couple minutes, if not seconds, to know if that's the car that you really want to buy, those are the seconds that really matter. Now, as absurd as that sounds, that's exactly what the government's been doing in their entire investigation. They're trying to talk you back to the jury room and tell you, oh no, don't put this case to the test. Here, sign the verdict form. Members of the jury, when it comes down to it, this case is simple. I agree with counsel. It's a simple case. And the question is this: what happened in those 3 seconds before the gun went off? Now, before I go any further, let me make one thing absolutely clear to all of y'all. It is not now, and it has never been, our responsibility to prove that what happened that night was an accident. Members of the jury, it was their responsibility to prove that it wasn't. Not just to prove it beyond a reasonable doubt. It was their burden to rule out every single reasonable possibility that it could have been an accident, and they didn't do it. Let's walk through what actually happened that night. Today, the government has been desperately hinging their case on the fact that Ms. Patterson was emotional that night. She had been arguing, and yes, she was drinking. But they point to these things as evidence that the shooting was intentional. Think about that. Those things just make it all the more likely that Ms. Patterson would have tripped and fallen in the parking lot that night. Not even the government's own crime scene investigator was able to walk there without tripping and falling. And she wasn't emotional. We sure hope she hadn't been drinking. No, she was attentively and cautiously focusing on her surroundings. And what's more, she even brought lights into the parking lot that night to help her see. And she still tripped and stumbled over the cracks and potholes in that parking lot, not once, but multiple times. Members of the jury, that alone is reasonable doubt. But there's much more. We know from a gun expert that the gun was prone to accidental discharge. And you heard from an eyewitness who literally watched as Miss Patterson got stuck and tripped in the parking lot that night. Now, those two witnesses, they tell us exactly what happened in the 3 seconds before the gun went off, but the government never bothered questioning either of them, at least until today. And why not? It's not like they didn't have access. Miss Franklin literally lives in the same 2-story condominium right down the hall from the government's own witness, Miss Anderson. And the gun expert literally works for the government in law enforcement. Now, even though the government didn't choose to investigate those 3 most important seconds in this case, you'd think that at least they'd want to show you what they did investigate. But members of the jury, they didn't even do this. We know that the crime scene investigator photographed over 24 different areas and took who knows how many pictures. Why didn't the government want you to see these? What would these pictures have shown you? Just how far from the car or the body was the gun? Just how dark was that parking lot that night? How many of those potholes were right next to where the car was parked? In just a few minutes, Judge Clark is going to take you back and explain to you that your verdict cannot be guilty unless your mind rests easily as to the certainty of guilt. And members of the jury, if you're wondering what even one of those photographs would have shown you, then your mind is not resting easily, and that is reasonable doubt. This is exactly the kind of case that should make us thankful for the American justice system. Because the government didn't do its job, and they chose not to investigate what mattered most in this case, which is the 3 seconds before the gun actually went off, we did. And so can you. You now have a chance to make right what the government got wrong. And for all these reasons, we ask that you find Peyton Patterson not guilty. Thank you.
Is there time remaining? All right. You have 55 seconds. You may proceed.
Yes, Your Honor. Members of the jury, Miss Siegel just got up here and told you that we had to prove intent in this case. That is not what we had to prove to you today. We only had to prove to you that Miss Patterson acted knowingly. She is trained in gun safety. She knew she was upset that night. She knew she was angry when she went down to that car. She knew that a gun should be stored safely. She knew that it was unsafe to put your finger on the trigger of a gun. She knew especially that you do not aim a gun at a person unless you are going to shoot them. Ladies and gentlemen of the jury, Miss Patterson acted knowingly, and that means you must find her guilty. Thank you.
Thank you to each side for their presentations here. This court is now going to be in recess so that the jury can deliberate, and we will return to the courtroom as soon as those deliberations are completed and announce all decisions.